Ule.
Lordship.
Yes,
Let us
Mr.
kindly
Silo.
indulgence. Your Lordship, regarding item 25 of today's list. It's the last item.
Section 4 POXO.
Yes, Your Lordship. If this matter, after consulting with the councils, if this matter can come up.
Monday?
Monday,
We can have it on Monday?
My lord.
oblige.
As prayed for by Mr. Jonathan L. Silo, Leonard Amicus Curie, for the appellant which is not opposed by Mr. C. Thiangkleama, Leonard Legal Aid Counsel, for the respondent number 2, and who is appearing for the APP?
Miss Mary, I think.
Miss Mary or Miss Linda? Miss Linda, Leonard PP, repost on such and such date.
25th May.
25, last.
Oblige.
May I seek a Lordship indulgence in mentioning Part 2, Item number 3. Lordship, although today is a fixed item, my senior, the leading counsel, has some personal difficulties.
When
So-
do you want it?
After 1 week, Lordship.
After?
1 week, if possible.
Next week.
Oh, yes, Lordship.
If you want it before 29, then sorry, this part 2 list is only for this week.
This week.
Yes, Lordship.
Yesterday, there were few part 2 matters which I thought got fixed next week. I don't know if they have passed judicial orders or not. You look into it. If those were, they got it fixed on Thursdays. No, there was one matter which was fixed on Thursday next week of Jordan, I think. You just check up, huh? Because I was thinking this is a 2-weekly list, so this is only for this week. Item 3, when do you want it?
On the first week of June, if possible, Lordship.
All right, as prayed for by MS,
Lero Pari.
so and so, Learned Counsel appearing for the appellant which is not opposed by the other side.
Yes, Lordship.
Repost on such and such date.
2nd of June.
They be obliged.
Your Lordship, I would like to seek the court's indulgence in mentioning item number 13 of Part 2.
Item number
13.
part 2.
Yes, Your Lordship.
When do you want it?
Your Lordship, the appellant is seeking to engage another senior outstation counsel as the current one is unable to make an appearance, so if further time may be granted for such arrangement.
So, Mr. Bora is not going to appear in this matter?
Yes, Your Lordship.
Huh?
Yes, Your Lordship.
Your name?
Sarah Alal Bensange.
So and so, Learned Counsel appearing for the appellant submits that the earlier engaged senior counsel is no longer going to be appearing in the matter for the appellant and accordingly seeks a short accommodation for making necessary arrangement in the matter for representing the appellant by a learned senior counsel. Prayer is not opposed by the PP, repost on such and such date.
4th of June.
MS Linda, give her name.
May I seek your Lordship's indulgence in mentioning item 24 of today's list, my lord. If this item may be listed after 2 weeks.
Yes, it is in the hearing list.
My lord, however, my senior has
Mr.
a hearing-
Malhotra,
Yes, hearing matter in
have
the
you
other-
informed the other side? I find senior counsel, Mr. Lian Shrima is also there. Anyone, have you any objection?
No, my lord, we don't have any objection.
Okay, as prayed for by MS Abigail.
My lord, Violet Kamwane.
So and so learned counsel appearing for the appellant on the ground that the conducting counsel, Mr. A.R. Malhotra, has some personal difficulty today which is not opposed by the respondent side. MS Ruth, na?
Ruth Lalwatfali.
MS Ruth Lalrufeli, learned counsel, appearing for respondent number 2, and MS Vani, learned counsel, appearing for
Respondent number 1.
respondent number 1, repost on such and such date.
1st of June.
Please call the list.
Daily list for motion, item 1.
Mr. Medhi, what is this writ petition?
Writ petition, my lord, this is the 4 writ petition regarding interest under section 34, my lord. Item number 1, 2, 3, and 6, my lord.
Yes, some assessment has been done by the collector.
Yes, my lord.
You
So
are
far, this is
challenging
out-
that?
Yes, my lord, because my lord,
But
we
is
have
there
the
no, is there no appellate remedy? Is there a statutory remedy available against the assessment of the collector?
No, my lord, no, my lord. We can approach High Court, my lord. The other cases, my lord, we had already filed appeal also, my lord.
Where are
The appeal
those?
is pending.
Do you
Yes,
have
my
any
lord.
similar order?
Yes, my lord, it is annex, my lord, in the
Where?
writ petition itself, my lord.
Land Acquisition
Yes, my lord. Lordship may turn,
Act and also get the Drugs, Cosmetics Act and Custom Act. This is-
page 31, my lord. Page 31, my
The
lord. this-
assessment is done under section 34 of the LA.
Yes, my lord, from the date of possession, my lord. We have already paid the award under section 11, my lord. And thereafter, again, my lord, that compensation against, my lord, again, they assess, my lord. This relevant page is page 45, my lord. This, in rate petition also allowed the same interest, my lord, from the date of possession, my lord.
Page,
We have
page,
challenged,
page.
page 45, my lord. And another is, my lord, page, my lord, another page 47, my lord.
Page.
Page 47 also, my lord. Yesterday, some matter was listed before this honorable court, my lord, regarding 34, my lord. This and contempt also was there, my lord. So that order was stayed, my lord. Writ petition.
But what is wrong in this order?
Wrong order, my lord. My lord, there is award was passed initially it was under section 11, my lord.
Yes.
This 11 award, my lord, we have paid immediately, my lord.
You have paid immediately.
So, yes, my lord. So thereafter, they approached the reference court, my lord. Reference court assessed initially the land value was nil, my lord.
Yes.
Reference court, my lord, revalued the land, my lord, and 25, my lord, per square feet, my lord. So it was, my lord, reference court, my lord, also directed to pay them, my lord, pay them the under section 28 and 34 interest as per act, my lord. 34 is comes, my lord, only when delay payment is there, my lord. So we paid the amount initially in the year, my lord, immediately after award was passed, my lord. So that, my lord, the compensation is, this is not compensation, my lord. This is, my lord, whether their
All right.
amount.
All right. Heard Mr. S.K. Medi, learned counsel, appearing for the petitioner. By way of this, you are appearing, Miss
Lalnan Louis, Your Lordship.
Lalin Louis, learned government counsel for the. You are appearing for all the respondents.
No, Your Lordship, only these state, that is respondent number 1 and 2, the rest are private.
For respondent number 1 and 2, huh?
Yes, Your Lordship.
You want to say something, Miss Lalin Louis?
No, Your Lordship, not at this stage.
By way of this petition under Article 226 of the Constitution of India, the petitioner is assailing the assessment order dated the letter of assessment dated 14/1/2022 made by the District Collector Kolasip.
Annexure B.
Huh?
Annexure B, my lord.
Sorry?
Annexure B, my lord.
It is the contention of the learned counsel appearing for the petitioner that because in the instant case the land value was 0 when compensation under section 11 of the Land Acquisition Act 1894 was determined, statutory provision under section 34 for interest is not attracted. Accordingly, the order of the assessment whereby interest is granted under section 34 is
My lord, from the
illegal.
date of possession, my lord.
Huh?
But from the date of possession, my lord.
From the date of possession is without authority of law. That's your
Yes, my
submission.
lord. Yes, my lord.
is without authority of law. It is brought to the notice of this court that similar issue is pending before the division bench of this court in
Appeal number 265/23.
WA 8 of 2024. Huh?
My lord, lordship made 265 to 2023 and 320 of 2023. That may be recorded.
WA
265
265 of
23, my lord.
2023 and WA 320 of 2023.
Yes, my lord.
Wherein there has been stay of the order passed by the district collector.
No, my lord. There is this writ petition order also state, my lord.
Yes, I
Writ
know.
petition-
Yes, I know.
Yes.
Along with the impugned order of the learned single judge appealed, against which the appeal has been filed. Issue notice making it returnable on such and such date. So and so accepts notice for 1 and 2. Speed baki steps koi diba within 3 days for the rest of the respondents. In the meantime, the effect and operation of the assessment impugned letter of assessment dated 14/1/2022 made by District Collector Kolasip is stayed till further orders.
11th June.
Now, in the item number 2, 3, 4, 5, 6, the date would be different.
My lord, 2, 3, my lord, 2, 3 and my lord, 6 is same, my lord.
2, 3 and 6 is the same date.
Date is different, but issue is same, my lord.
So, 2, 3 and 6 are eke hobo, khali date to sailoba from the prayer. And
And-
what
and
about
respondents-
4 and 5?
My lord, my 2, 3 and my lord, 6, my lord, private respondents, they are different, my lord. Private respondent is there.
To sailoba.
And my lord, so far, 4 is concerned, my lord, is section, relating section 28, my lord.
Ms. Ruth,
Yes,
Ms.
Your
Lalan Louis, please give your appearance in respect of all the matters wherever you are representing,
Yes, Your Lordship.
whoever the respondent.
Yes, Your Lordship. I'm
Just
appearing in
can
all.
you put it in a piece of paper and give her a
Okay,
paper?
yes, Your Lordship.
She's given. Yes, what about in this item?
Item number 6, my lord.
Yes.
WBC 58 of this, lordship met on page 10, my lord. Page 10, my lord.
Here the assessment is challenged.
Yes, my lord, regarding 28, my lord. 28, my lord. The district collector has no authority to pay the interest under section 28, my lord.
What are you relying on this order?
Yes, my lord. Yes, my lord. There's the lordship may this order, my lord. Writ appeal number 320, my lord. 320.
Page?
Page, my lord. Page 40, my lord.
Heard Mr. S.K. Mehdi, learned counsel appearing for the petitioner. Also heard M.S. Lalan Louis, learned counsel appearing for respondent number 1 and 2. Correct?
Your Lordship, in
Yes.
the analogous, if
I think 1 and 2 in item 4.
yes, Your Lordship.
By way of this petition under Article 226 of the Constitution of India, the petitioner is putting to challenge the impugned order dated 8/9/2022 passed by the District Collector Kolasip, as well as impugned letter of assessment made by the District Collector Kolasip dated 12/9/2022. It is the contention of the learned counsel appearing for the petitioner that the impugned assessment impugned order is impugned order in 8/9/2022 is passed under section
Under section 28, my lord.
under section 28 of the LA Act without
But-
any
But the district collector has no authority. Court can pass an order, my lord.
without any authority, inasmuch as it is the court which is competent to pass an order under section 28 of the LA Act and not the district collector. Correct?
Yes, my lord. Yes, my
Issue
lord.
notice making it returnable on such and such date. steps, so and so extra copies, huh?
11th June.
In the meantime, the ordered so and so is stayed till further orders.
My lordship also put the writ appeal number 8 up to 24 also, my lord.
Similar orders to Likhidiba 8 or 322. It is
Eight.
better, understanding.
Page 16, my lord. Page 16.
Okay,
my lord.
done. Next.
Item 5.
Item 5, my lord, is I want to withdraw this petition, my lord.
Okay. Just 1 second. Pranab. He item 4 to duta impugn duta order ase. Tumi he interim order sai loba tate reference to pai jaba. And in
No,
item
my- no,
5,
my
heard
lord-
Mr. S.K. Medi, Learned Counsel appearing for the petitioner. Anyone
My lord,
appearing
my-
for respondent?
My lord, item 5, my lord, I want to withdraw this petition.
I
my lord. Item
understood.
5.
1 second. You
Yes,
don't have to
ma'am.
repeat your submission. Miss Mary, you're
Yes,
there?
ma'am.
Yes, Your Lordship, for 1 and 2.
MS Mary, Learned Government Counsel is appearing for respondent number 1 and 2.
Yes.
You're appearing as additional
Government advocate in the matter.
Government Counsel. Mr. Mehdi, Learned Counsel for the petitioner submits on instruction that he wants to withdraw the case
With the liberty to file
with
fresh, my
liberty
lord.
to file a fresh. Prayer is not opposed. Writ petition stands withdrawn on liberty, with liberty to file a fresh.
My lord, so far item
Item
4 is
6.
concerned, my lord, my lord, so far item 4 is concerned, my lord, there's 2 writ appeal, my lord. I indicate 2 writ appeal number.
Yes, I have already ordered it. I
Yes,
have
ma'am.
given
Thank
writ appeal 8, and you see the problem
Yes.
is that you appear
Yes.
through video conferencing mode, you do not hear properly. I've
So-
already
sorry, ma'am.
recorded it. You be more
Sorry, ma'am.
alert next time.
Yes.
Yes.
Item number 6 is concerned, my lord, is related section 34, my lord, similar to item number 1, 2, and 3, my lord.
A withdraw to 5 asil na. Item number 6 I think is similar to 1, 2 and 3, right?
Yes, my lord.
Okay, that is same.
For admission,
Aye, Abraham.
item 7.
My Lord, I'm appearing on behalf of my senior, Mr. A.R. Malhotra, who is the
Mr.
counsel
Joseph,
for...
this is some appointment of R5 to the
Yes.
Mizoram University, post of
R6,
registrar.
Yes, my lord.
R6.
Yes, to the registrar. my lord.
You are challenging the appointment.
Correct, my lord.
On what ground?
My lord, the first ground is, my lord, on the ground of bias, Article 21. Our contention, my lord, is that this registrar, even though he was participating as a candidate for this post, my lord, all throughout the entire recruitment process, my lord, he had taken part as an employer on the side of the employee. He was there in the meeting. He was the one who was sending out all the emails and things like that. So that is the first ground, my lord, on the issue of bias. And the second issue, my lord, we have contended is that he has overstayed his deputation period. So these are the two grounds, my lord, on the basis of which we
And
challenge.
who are you?
My lord, we were also participating in this recruitment process, and our names also were shortlisted.
R6 is represented by Mr. Malhotra.
Correct, my lord.
You want time.
My Lord, if this item may be fixed next Tuesday, that is on 26.
My lord, if it's fine, my lord, Tuesday.
Okay. What about Ms. Ruth?
Yeah, I have no objection, my lord.
Heard Mr. Joseph, so and so, Learned Counsel appearing for the petitioner. Also heard MS,
Wale Samwani.
so and so, Learned Counsel appearing for respondent number
6.
6, and MS Ruth, Government Counsel, na?
No, my lord, I'm for MZU, Mizoram
Oh, you're
University.
appearing for the university.
Yes, my lord.
Appearing for the respondent Mizoram University, and is government there?
No, government is not there.
Okay. As prayed for, no, as prayed no, MSC respondent 6, take it on number 21, seeks a short accommodation on the ground that the conducting counsel, Mr. A.R. Malhotra, has some personal difficulty today. Prayer is not opposed, repost Tuesday.
26 May.
But I think there is a judicial order to dispose it of at the admission stage.
Yes,
I think that is there.
yes, it's there, my lord.
So you inform Mr. Malhotra to be ready.
Yes,
On Tuesday, we will try and dispose of this
Yes.
matter.
Item 8.
my lord, this.
Washing.
Yes, my lord, this matter we are
My lord,
ready for
but-
disposal today, my lord, if it's possible.
My lord, before starting my prayer, my lord, actually I want to place one judgment, but it was not sent to the registry, my lord.
What judgment?
So, my lord, relating to my lord, there is judgment of the Madras High Court, my lord.
What
I have
Madras High
men-
Court judgment?
Yes, relating to, my lord, this responsibility, my lord, responsibility, my lord,
You give it.
responsibility.
You give it. Ask your junior to send it right now. You just have to email it. Email it to the court master. I'm hearing it.
If lordship may, day after tomorrow, my lord, this,
Why all matters are getting adjourned?
day after tomorrow, my lord,
My lord, I can start and then he can reply day after tomorrow.
Mr. Joseph, Mr. Mehdi, why don't you email it to the court master?
Yes.
Let me first hear the petitioner.
Yes.
my lord, I sorry, my lord, I try to send my some.
No, that's all right. You send it now. Give us the citation. What is so difficult?
Citation is already in my affidavit is there, my
Which page?
already. Yes, my lord.
Mr. Joseph, ask your junior to download it. Which page in your affidavit?
Yes, my lord, I'm coming, my lord. Page 11, my lord.
Yes, which page? You don't even know
Page
the page.
11.
Page?
11, my lord, 11.
Page number 11.
Of my objection, my lord.
1 second.
Moreover,
Yes, I've got it.
Just see, send it to the library if you can get it.
Mr. Joseph, you've got the citation
I think it will be there, my lord. We have it here.
at page 11.
Page 11, Madras High Court.
Madras High Court.
Judgment, my lord. We will try to download.
You ask one of your junior to see if she can find it. In the meantime, yes, this is a complaint case.
Yes, my lord.
Where is the complaint?
My lord, the complaint is at page number 62. 62 is where the contents of the complaint begins, my lord. And 60 is where the cause title begins, my lord. So I'll take your lordship straight to page number 62. My lord, before that, let me just highlight, my lord, the 2 points that we want to
Yeah,
raise.
just 1 second.
Yes, my lord, certainly.
Michael, can you just write it here? Just put it like this, whether this is the written objection, the rejoinder, and the additional affidavit. Just put it in seriatim. Affidavit, then reply, and then.
Yes, page 62 you said, no?
Yes, my lord. This is the complaint. This is where it begins, the content of the complaint.
You
Now, my
can
lord, the
briefly summarize
Yes,
it.
the 2 points, my lord, we seek to highlight, my lord. The first point, my lord, the applicants in this case, that is the accused persons, my lord, accused persons number 2 to 9. They have been accused on the basis that they were alleged directors in the company number 1, company of the respondent, of the accused person, party number 1. Accused party number 1, my lord, is a company called Algen. Now, applicants were made accused number 2 to 9 on the alleged grounds, my lord, that they are directors of this company. So they are saying that these applicants are vicariously liable for the misconduct of the company. That is the first.
Is vicarious liability there under the Drugs and Cosmetics
My
Act?
lord, it's there, but our contention, my lord, is this. Under the Drugs and Cosmetics Act, my lord, in the Supreme Court judgment of Lalan Kumar Singh, it has been clearly laid down, my lord, that it is not enough to state that they are directors.
There has to be some participation there, knowledge.
Correct. Knowledge, and also they have to state exactly in how and what manner they are involved in the company. My lord, that is the first. And
So
it is-
merely holding the post of director will not make them vicariously liable.
Absolutely.
They must have some role to play. Something has to be attributed. Some role has to be attributed to them.
Absolutely.
Correct.
That
This
that-
is what is your submission.
This is our submission, my lord. And the second ground, my lord, the process was issued by the judicial magistrate first class without complying with section 204 CRPC. So on these 2 grounds, my lord, we have challenged this criminal complaint, my lord.
What is the stage of the criminal complaint?
My lord, the criminal complaint is at this stage, I think it is at the stage of trial, but it has been kept in abeyance, my lord, because of this.
yes, my lord.
Okay.
Now, my lord, I will not take you through all the other facts, disputed facts. I will take you straight to the complaint, my lord. If
Yes.
your lordship will come back to page number 62, my lord.
Yes.
My lord, I'll read the complaint. That the complainant states that he has been appointed as drugs inspector by the government of India under section 21 of the Drugs and Cosmetics Act 1940, herein referred to as the Act for whole of India by notification in the official gazette, vide notification number so and so, dated 7/11/2013. Presently posted at office of the Assistant Drugs Controller, India, Drugs, Central Drug Standard so and so, and has official capacity to discharge his official duties, and he is the competent person to file the present complaint petition before the learned court in view of section 32(1)(a) of the Act. 2. That the complainant Sri Abu Hanif Imran Chowdhury is filing this complaint in official capacity as drugs inspector in pursuance of prosecution permission received from the Drugs Controller General so and so, vide number, letter so and so, my lord. Number 3, I'll go to number 3. That the complainant states that the sample Primaquine tablets, IP batch number so and so, manufactured by Algen Healthcare Limited, my lord, this is the accused person number 1, was manufactured under a drugs manufacturing license and is a drugs of high therapeutic value used as gematocidal drugs in P. falciparum infections to prevent transmission of falciparum malaria, particularly in area where there is potential for reintroduction of malaria by the Drugs Controller General of India, Directorate General of Health Services, so and so. 4th, now my lord, this is where it becomes important, that the complainant states that the accused number 1, MS Algen Healthcare Limited, is holding license to manufacture for sale or for distribution of drugs.
Your petitioner is accused number 2.
Accused number 2 to accused number 9. Is holding license to manufacture for sale for distribution of drugs issued by the Drugs Licensing Authority, Drugs Control Administration, HP Solan, vide license number so and so, and retention letter for license valid up to 10/11/2023, vide letter number so and so. There is no dispute that this license is valid. Number 5. The complainant states that the applicant number 2, also person responsible for day-to-day control of business activity of the company.
Mr. Joseph, the difficulty is that, you see, you've been referred in the complaint as that you are responsible in the day-to-day functioning.
Correct, correct.
Respondent number 8 is also the person responsible for manufacturing.
Yes.
Respondent number 9 is also the competent person who was responsible for testing of the drugs. Now, you see, this is quashing of the complaint.
Yes.
But what happens in the trial, we don't know.
Yes.
But nonetheless, the test that has to be applied is well settled. You test it in the face value.
Correct.
You take these averments on the face
On
of
the face
it
value. Correct, correct.
and see
Absolutely.
whether an offence is made out.
Yes.
Going by the apex court decision which you are seeking to rely,
yes.
that also says that if you are having some role to play,
Yes.
then you might be vicariously liable. Correct?
Correct.
Now the face of it, paragraph
Paragraph
5 and 6
Yes.
indicates that you do have some responsibility and role. I'm sorry, you got started and I am indicating my mind.
Yes, yes.
Because otherwise the law is very well settled.
Yes, yes.
Isn't it? It's a quashing of complaint.
My lord is right, my lord.
You are within a very narrow
Narrow compass. Now, my lord, with applicants, with respondents with accused persons number 2 to 7, my lord, they have only been named as directors, my lord. That's all.
So you mean to say no specific role?
No specific role has been
Is
mentioned
attributed.
with respect to the accused persons number 2 to 7. Now 8 to 9, my lord, your lordship is right. To a
Is
certain
specific.
extent, they have been mentioned
Is
that
specific.
yes, one is involved in the manufacturing and one is involved in the test. So even for the sake, my lord, let's exclude 8 and 9, but let's stick to the first few accused persons, my lord.
Whether this is sufficient
Whether this is sufficient, my lord, I'll take your
to
lordship
prima
straight.
facie fasten the vicarious liability.
Correct. My lord, I'll take your lordship to the judgment because I think
Yes,
your lordship
yes.
has already got the hang of this case.
Yes.
My lord, I have given the citation.
Yes.
This is reported in 2022, SCC Online SC 1383, my lord. This is also, my lord, this is also a quashing petition. It was against the process that was issued
Yes. Under the drugs and cosmetics.
under the Drugs and Cosmetics
Yes.
Act, my lord. And my lord, I'll take your lordship to paragraph number 26. straight to paragraph 26. Paragraph 26.
Yes.
It was held that merely because a person is a director of a company,
Paragraph 26.
26, my lord, has seen it?
Yes, you are relying on Lalan Kumar, na?
Lalan Kumar Singh, my lord. Paragraph 26.
Yeah, 26 reads as perusal of the order. This is from SSC Online. Are you holding it from some?
No, I am
somewhere
also
else?
from SCC Online, my lord. This is 2022
No,
SCC Online.
Paragraph, just have a look, Dina. Mr. Joram Chana, congratulations to you.
Lalan Kumar Singh. My lord, I think your my paragraph number 26 is the same as your paragraph number 16 for some reason, my lord.
It's not the same citation.
It's the same citation.
Well,
It's the
why?
same-
Because you are also holding SSC Online?
Yes, my lord, this is also SCC Online.
This is strange. Are you sure it's the same judgment? Just have a look at it. It may be the same name or something. How can it be?
It's the same judgment, my lord. The citation is also similar. The judge also is similar, my lord.
Okay, give it.
Very weird. I should have given a printed copy, my lord.
No, that's all right.
My lord, paragraph number 16 in yours, paragraph
Yes.
number 26 in mine, my lord. It says like this.
Yes.
It was held that merely because a person is a director of a company, it is not necessary that he is aware about the day-to-day functioning of the company. This court held that there is no universal rule that the director of a company is in charge of its everyday affairs. It was therefore necessary to aver as to how, my lord, this is important, as to how the director of the company was in charge of day-to-day affairs of the company and responsible to the affairs of the company. My lord, in our case, as to how has not been mentioned only. This court, however, clarified that the position of a managing director, my lord, we are not managing directors, position of a managing director or a joint managing director in a company may be different. This court further held that these persons, as the designation of their office suggests, are in charge of a company and are responsible for the conduct of the business of the company. To escape liability, they will have to prove that when the offense was committed, they had no knowledge of the offense or that they exercised all due diligence to prevent the commission of the offense. So, my lord, the second part where they have to prove is only with respect to the managing directors, my lord, not the directors per se. 27. In the case of Pooja Ravinder Devidas Sani versus State of Maharashtra, this court observed thus: every person connected with the company will not fall into the ambit of the provision. Time and again it has been asserted by this court that only those persons who are in charge of and responsible for the conduct of the business of the company at the time of commission of an offense will be liable for criminal action. A director who was not in charge of and was not responsible for the conduct of the business of the company at the relevant time will not be liable for an offense under section 141 of NI Act. So and so, this court observes, section 141 is a penal provision creating vicarious liability and which as per settled law must be strictly construed. It is therefore not sufficient to make a bald cursory statement in a complaint that the director arrayed as an accused is in charge of and responsible to the company. This is exactly what they have done, my lord, for the conduct of the business of the company without anything more as to the role of the director. But the complaint should spell out as to how and in what manner respondent number 1 was in charge of or was responsible to the accused company for the conduct of its business. It is in consonance with the strict interpretation of penal statutes, especially where such statutes create vicarious liability. 14. A company may have a number of directors, and to make any of all the directors as accused in a complaint merely on the basis of a statement that they are in charge of and responsible for the conduct of the business of the company without anything more is not a sufficient or adequate fulfillment of the requirement under section 141. In Girdari Lal Gupta versus D.H. Mehta, this court observed that a person in charge of a business means that a person should be in overall control of the day-to-day business of the company. A director of the company is liable to be convicted for an offense committed by the company if he/she was in charge of and was responsible to the company for the conduct of its business, or if it is proved that the offense was committed with the consent or connivance of or attributable to any negligence on the part of the director concerned. In other words, the law laid down by this court is that for making a director of a company liable for the offenses committed by the company under Section 141 of the NI Act, there must be specific averments. My lord, this is only missing in us. There must be specific averments against the director showing as to how and in what manner the director was responsible for the conduct of the business. My lord, if I had taken your lordship through the complaint, nothing of this sort would have been found. 21. In Sabita Rama Murthy versus so-and-so, it was held by this court that it is not necessary for the complaint to specifically reproduce the wordings of the section. In us, they have reproduced the wordings of the section. But what is required is a clear statement of fact so as to enable the court to arrive at a prima facie opinion that the accused is vicariously liable. Section 141 raises a legal fiction. By reason of the said provision, a person, although is not personally liable for commission of such an offense, would be vicariously liable therefore. Such vicarious liability can be inferred so far as company registered or incorporated under the Companies Act 1956 is concerned, only if the requisite statements which are required to be averred in the complaint petitions are made so as to make the accused therein vicariously liable for the offense committed by the company. By verbatim reproducing the words of the section, my lord, this is exactly where these people have fallen down, my lord. By verbatim reproducing the words of the section without a clear statement of fact supported by proper evidence. My lord, this is also important. The reason I say this is, my lord, they have mentioned, even with respect to 8 and 9, my lord, they have mentioned that one is a manufacturing agent and one is testing the so-and-so. But the evidence they have produced, my lord, is only one Aadhaar card. That's the evidence they have produced. So, my lord.
But you see, that is very premature. There is something specific, but then you haven't reached till para 24. I don't know what is that paragraph in your
my lord, is it paragraph?
citation.
Does it start with it could thus clearly be seen?
No, it is further to be noted that in accordance with the provisions of Rule 76. Maybe you haven't reached there. You can go on because there they are talking about accused 10, who was approved as a head of testing unit.
Acha. So, my lord, let's put this.
So even he was actually ultimately he was also the complaint was withdrawn, quashed against him as well.
Yes.
Because he was just merely referred as the head of the
head.
testing.
My lord, but I'm not sure where that one is because
Which one?
the one which your lordship has just read.
It starts. The paragraph starts at it is further to be noted.
Okay.
Towards the end.
Just to see that no specific the order of issuance of process. Okay.
Because ultimately here the complaint was quashed, right?
Correct. Yes, my lord, paragraph 34 in mind.
Yes.
And my lord, in this case also it was squashed, and I think they have done the same error has happened in our case also. The reason I
Did you
say
just read that para 34?
34. It is further to be noted that in accordance with the provisions of Rule 76 of the said rules, read with Form 28, the accused numbers 9 and 10 have specifically been approved by the licensing authority in Form 28. Accused number 9 was approved as a person under whose active direction and personal supervision the manufacture would be conducted as required under sub-rule 1 of Rule 76 of the said rules. Specifically, accused number 10, who was approved as a head of the testing unit, was to be in charge for carrying out the test of the strength, quality and purity of the substances as may be required under the provisions of Part 10 of the said rule. We are therefore of the considered view that the complaint is totally lacking the requirements of Section 34 of the said Act. So on the face value of the complaint, only even in this case it was quashed, my lord.
But in your case, what was the main crux of the complaint? That these drugs were not tested properly?
No, they are saying, my lord, these drugs were not of standard quality.
Not standard. That means that there is some defect in the testing.
There is some defect.
And the manufacturing.
That's basically, my lord, that part they have not mentioned. They are basically
but
saying that it's of
obviously-
substandard quality.
Correct. So obviously it has nexus with the manufacturing
Correct,
and
correct.
the testing.
Correct.
Now if we go by para 6 of the complaint, it is accused 8 and 9 who seems to be the persons who are responsible.
Yes.
But the other accused may be directors,
Correct.
but just because they are directors, they cannot be dragged into the
Definitely
criminal case.
Yes.
This is what you are basically saying. I'm
Yes.
sure you are also saying that 8 and 9 also cannot.
Okay, my lord, we can demarcate, we can split this into.
I'm thinking that.
Yes.
Because you see, it's very difficult
Yes.
at the complaint stage
Correct.
to give evidence
Yes.
of 8 and 9.
Correct.
How can they give evidence?
Yes, yes,
This
that's-
is only to start the investigation. Correct?
Correct, correct.
Apparently, there has been some substandard drugs. So, somebody has to be made accountable for it.
Yes.
Now, it is in the investigation
Yes.
stage. Right now, they have brought in everyone.
Correct.
All the directors.
The directors.
Without ascribing any particular specific role to them.
Yes.
Which does not appears to be correct, because merely if you go by the Supreme Court decision as well. Because at the end of the day, it's vicarious liability.
Correct.
There are certain conditions which needs to be fulfilled.
Yes.
So if we take this on the face value and we see that whether ultimately if this goes, a conviction is possible for accused 2 to 7, answer of course is no.
Yes.
In that case, we can quash it for 2 to 7.
2 to 7.
8 and 9, I don't think.
They can go through trial, my lord. So there, my lord, I think we can make that demarcation. I am at least, but my lord.
You see,
with-
because 8 and 9 at this stage I can say, because tomorrow after, right now,
After evidence,
the trial is on,
the trial is beginning, my lord.
trial is beginning. So if tomorrow no evidence comes, that is a different
That's a
thing.
different matter, yes. But my lord, there's one point. Let me push this point also, my lord. This is with regards to the process that was issued by the
Yes,
magistrate.
what about that?
Now, my lord, if your lordship will come to the first order, lordship will come to the Roman page number 2.
The complaint, otherwise there is nothing more, na?
There is nothing more, my lord.
Mr. Joseph, I'm not reading the entire thing.
My lord, you can ask Mr. Mehdi also. If there's anything more, I think he can mention. My lord, the Roman number 2,
Yes.
I will read. My lord, I'll read from paragraph 2 itself only.
Page?
This is at Roman page 2, my lord, in the beginning.
Roman page 2. Yes.
My lord, first paragraph, the court has basically only explained the parties. Who are the parties?
So that Madras High Court you got, na? Mr. Mehdi, just for your consumption, my court officer has got the Madras citation.
Sorry, my lord, sorry.
Only for your consumption. Yes.
Yes.
So paragraph 1, my lord, I will not read. My lord, I'll come to paragraph 2. It says simply like this, my lord. Peruse the complaint petition along with the annexures. The complainant, being the public servant, submitted this complaint in writing, purporting to act in the discharge of his official duties, and as such, I did not examine him under section 200 CRPC. And straight, my lord, paragraph 3. I find prima facie case against the accused persons, Algen.
How?
so
On
and
what
so.
basis?
Now, my lord, if you take
No application of mine.
no application of mine. And my lord, if you go to the same judgment mentions this, my lord. My lord, in mine it is at paragraph number 38, the order of issuance of process. Your
Yes,
lordship,
I have
is
read it. It's
Yes.
not an empty formality.
It's not an empty formality. And
I've
my lord,
read
if your
it.
lordship, the quoted version at paragraph 53, they have
Yes,
the
yes.
Supreme Court has quoted, says like
Yes,
this.
yes.
Sufficient ground. And
you
on
see,
this,
you don't need to hold a mini trial.
Yes.
You're not even expected to go for a mini trial. But some application of mind in the context of the facts is required.
correct.
So basically, the judicial officer is required to see if the allegations prima facie is of such
Yes.
that these persons can be fastened with the vicarious
Correct.
liability. That's all.
That's all.
But that was not done.
That was not done.
Because we don't find it's not
don't find.
it's not recorded.
Yes.
It seems it's a very mechanical exercise of mind.
Correct, my lord. And the Supreme Court has specifically stated like this, my lord. Formation of such an opinion is to be stated in the order itself.
That's what I'm saying.
That's not there.
That's not there.
Yes.
So when it is not there, how do we know?
So, my lord, on these two grounds, my lord. So, the first ground is, my lord, supposing this second ground is not accepted, my humble submission is that directors, my lord, 2 to 7 still go. And the second ground, my lord, because of the second ground, the entire thing needs to be quashed. That's my submission, my lord, humble submission.
While I hear the other side, can you ask your junior to find out? I think this is on this application of mind.
Yes.
Most likely the GTV case. I think there was a famous Supreme Court decision. Most likely, it could be the the GTV case. Huh?
Okay.
Just have a look. If you, I think your junior also got that Madras High Court. But I think it's the same. Mr. Michael has also procured it from the library. Just see if it's the same.
Yes. I think it's the same, my lord.
Yes, Mr. Mehdi.
My lord, so far, my lord, this criminal petition is filed, my lord. The petition has not filed the complete complaint petition, my lord.
Where is the complete complaint?
Yes, my lord, this which I filed before the court below, my lord.
Where is
so
it?
far, yes, my lord, it is not here complete, my lord. So far, I am reading the annexer Romans 15 of the original complaint petition. It is
Where
not
do
here,
I
my lord.
find it?
Yes, my lord, it is not here, my lord.
Where do I find it?
My lord, they have not annexed the complete
No,
complaint
that's
petition.
okay. Then where is the complete complaint?
My lord, it required to call for, my lord, from the court below, my lord.
Why did you not annex it in your affidavit?
That is also there, my lord.
Why did you not annex it? If that's your stand? You filed your affidavit way back in March 25?
Yes, my lord.
Then why are you
And
not?
what-
If you had access to the complaint, you could have filed it. You could have procured it.
And
And what is
here,
not
my lord,
complete?
yes, my lord, the annexer 15 of the complaint, my lord.
Yes.
Roman 15, my lord. It is not here, my lord. I am reading, my lord. Here, my lord, the present petitioner, my lord, Sanjeev Kumar Bhatia, my lord, he himself, my lord, I am reading, with reference to letter dated 2/5/2022, file so and so, I have received an investigative
Where
letter.
are you reading from?
My lord, the original complaint which I filed, my lord. I am just reading.
Where is
for your-
it?
It is not here, my lord. It is.
Mr.
before
Mehdi,
the-
I'm asking a very specific question. If you have the original complaint in your hand, why have you not put it a photocopy of that in your affidavit?
Yes,
You
my
had
lord,
filed an
earlier-
affidavit. You should have
Yeah,
brought it
earlier-
on record.
Earlier
The
occasion,
matter
I
is
could
now
not be-
taken up for hearing.
My lord,
You had all the opportunities.
It was required to call for also record.
Why should this court call for it when you have a copy of it? You have a copy? You have
Yes,
the
I-
original
I-
copy? What
Yes,
prevented you from bringing it to the court?
Yes, my lord. I have not prevented, my lord.
Why? This is how the matters are getting delayed in the court.
No, my lord. No, my lord. No, my lord. This already, my lord.
You give it by tomorrow. I'm having this matter fixed tomorrow. You have the original
Well,
copy, you get it, you furnish the complete copy before this court.
My lord, day after tomorrow, my lord. And then
What is the problem tomorrow?
Tomorrow I have some cases fixed, my lord, in
So?
principal bench, my lord.
So, how
So,
are we
no-
concerned? You will have to
My lord,
find
I
time
don't-
for it. This is
My-
not how
my-
matters keeps on getting adjourned.
My
This
lord,
matter was taken
lordship
up
may
today.
lordship may turn page
Mr.
95
Joseph,
of the.
is that,
My lord,
My lord, we have,
My lord,
we,
my lord,
we have
lordship
enclosed,
may,
we have enclosed everything, my lord, including the annexures in the complaint. In fact, my lord, because we had failed to annex one, we had filed an additional affidavit, my lord. And there we have also included one of the annexures which we had by mistake, my lord, not included.
where is that?
The additional affidavit, my lord, we had filed.
Yes.
Now we have, by this affidavit, we have submitted the,
Is it the form 28?
yes, we had submitted Form 28, which is the test report.
Who's Navneet Marwa, the state drug controller?
We have included everything, my lord.
well, but from their additional affidavit also, I try to submit, my lord, one thing, my lord. The Sanjeev Bhatia, he is the managing director, my lord. He manages everything, my lord.
Sanjeev,
Sanjeev Bhatia, my lord.
he is the director.
Yes, my lordship, for this, I want to show, my lord.
Page
this-
7
this-
indicates his designation as a director.
Page 7, my lord, page 7, my lord. Lordship may turn page 7, my lord, of additional affidavit. my lord.
Yes, I have page 7.
Yes, my lord, for the extreme left side below, my lord. For Ellen Healthcare so-and-so, this signature was put by Sandeep Bhatia, my lord.
Yes.
Yes, my lord, he is managing, my lord. And thereafter, my lord. I want to
Mr.
show, my lord-
Mr. Medhi,
Yes, ma'am.
in the list of directors at page 7, the annexure number 2, the designation of Sanjeev Kumar Bhatia
Yes,
is
madam.
mentioned
Yes,
as
madam.
director. He
Yes,
is the
madam.
director.
Yes,
Yes.
madam.
And you see, Mr. Medhi, please try and understand what is happening. The ground of challenge is because in the complaint at paragraph 5,
Yes, madam.
it is mentioned that accused number 2, also person responsible for day-to-day control of business activity of the company, 2-7
Yes, madam.
are the directors of the accused firm. That's it.
Yes, madam.
Now,
Yes, my
now,
lordship.
Mr. Medhi, you have to show me from the complaint one paragraph wherein you have attributed specific role against accused number 227.
My lord, I only want to show one thing, my lord.
Yes.
Page 95 of this present petition, my lord.
Page 95.
95 of.
Yes,
The letter is 6/5/2019, my lord.
yes.
It is written to the Drugs Licensing Authority, my lord. My lord, this so-and-so meeting held on so-and-so, decision so-and-so, so-and-so. And Rohit Sharma has been appointed for the day-to-day activities of the firm for the conduct of business as per section so-and-so, drug so-and-so, so-and-so. He is authorized to sign all documents.
Who is
Both
Rohit
from-
Sharma? He is accused number?
He is not the accused, my lord.
Huh?
He is not accused, my lord.
He is not an accused.
Last signature, my lord, for all Elgin Healthcare, my lord, this director of signature is my lord Sanjeev Bhatia. Extreme late below, my lord.
Maybe.
And another
You
thing,
see,
my lord, another thing,
Mr. Medhi, there is no dispute about the fact that Bhatia is not a director. Bhatia is
Yes, madam.
admittedly a director.
Yes,
Are you
madam.
following what is happening or not? There is no quarrel about Bhatia being a director. What is being brought on, the contention of the learned counsel for the petitioner is that accused number 227 are directors. But
Yes,
in order to fasten vicarious liability on them, there must be some averment in the complaint to show that they have some involvement, they have some role to play in the commission of the offence alleged.
and all
As far as 8 and 9 are concerned, there are sufficient evidence, so that you need not worry. I am not going to quash it for 8 and 9. But for 2 to 7, unless you show me from the complaint that there is some specific role that you have attributed, it appears that it is in general. Then this goes against the decisions of the apex court.
Yes, my lord.
It is only
My lord,
that. You
my
show
lord,
me from the complaint.
My lord, in all documents, my lord, the Sanjeev Bhatia, he put his signature.
All right, noted. So that
Yes.
is your submission, that he has
And another-
signed all the
another-
documents as a director.
Yeah, in all day-to-day, my lord.
Now, that is all
And-
right.
yes, and
Mr.
another thing I want
Medhi,
to-
that is okay.
Another
Accepted.
thing-
Anything more?
Another I want to show, the affidavit, my lord, signed, the page 34, my lord, of the present petition, my lord.
Yes.
Page 34, my lord.
Yes. Sanjeev Bhatia, yes.
Yes, being one of the so-and-so applicant, accused person being accused, all facts, I am competent to swear this, swear affidavit on behalf of the applicant.
All right,
of-
noted. Who is Bhatia? His accused number?
He is my accused number 2.
Anything more?
And another thing, my lord, the way of this, my lord, the additional affidavit is filed, my lord.
Yes.
And additional affidavit which is filed, my lord. The page 6, my lord.
Yes.
Authorization letter, my lord. He authorized, my lord. I am one of the petitioners. So and so.
Where? Page?
Page 6,
Yes,
my lord.
yes, I've got it, yes.
Page 6, my lord.
Yes.
I have been authorized by all other petitioner in the said application to take every step
All
required
right,
on their behalf.
noted. So he has
And-
been authorized by the other petitioners to take steps on their behalf.
My lord, there is no such authorization in the authorization, my lord. This in affidavit filed, there is no whisper, my lord. The affidavit filed in the petition also, my lord. Page
Okay.
34, my lord.
Okay.
And another thing is, my lord, this lordship also, my lord, one thing, my lord, this reply filed by them, my lord. Reply
Yes.
filed by them, my lord. Yes, my lord.
Page
My lord, this, my lord, page 13, my lord.
of the rejoinder.
Yes, yes, my rejoinder, my lord.
Page,
13, my lord.
yes, authorization letter, yes.
I have been authorized by other petitioner to file the present
Yes.
petition so and so. However, since I am presently so and so, I have authorized Joshua so and so to swear this affidavit. This Joshua is nowhere related, my lord. The man, my lord. Page 13, my lord. This is a criminal petition, my lord.
Mr. Joseph, who is this Joshua Lalrem Ruata?
No, now, my lord, what has happened was because these people are outstationed. So because of this reason only they have authorized this person to sign on their behalf in Aizawl. Otherwise, my lord, they would have
No,
to.
who has signed, who has,
My lord, Joshua is one person from Aizawl.
that's all right, but who has filed the affidavit in this reply affidavit, rejoinder? Who is the person?
By the respondent.
By Joshua. So he has been authorized to file the reply. Okay, understood.
Yes.
Okay, understood.
This is also signed by the Sanjeev Bhatia, my lord. This other person authorization is nowhere there, my lord. Only this man is he is the managing everything, my lord.
So you mean to say it is Bhatia who is managing everything?
Yes, my lord. In
Okay,
all records,
okay,
my lord,
understood. Okay.
Yes, my lord. And the unknown person, in picture, my lord, this file
Anything
rejoinder
more?
itself.
Anything more?
And my submission, my lord, is so far Equus is concerned, my lord, so far the Sanjeev Bhatia is concerned, my lord, he is involved in day to day, my lord.
All
Because
right. I have taken note of it. Anything more?
The other, my lord, is already your lordship, this so far the Equus number 8 and 9 is concerned, but it is there, my lord.
That is all right. That is all right.
It is there. Here, my lord, the main Sanjeev Bhatia is the man. If this his
Very
my lord,
well. I've
this-
understood. You can now shift your attention from Bhatia. I have understood your submission for Bhatia. Anything
ma'am.
more?
Is completely their family. These all directors, their family member.
Okay. Mr. Joseph, I still have not understood what is the main offense that has been where in the complaint, which paragraph? Please point that
Yes,
out.
my lord.
I think it starts from 7.
Yes, it starts from 7, my lord, it goes on. But then I think the complaint, the prayer portion lists out the various provisions under which they have been charged, my lord, which is at page number 69, paragraph number 23, my lord.
Paragraph?
Number 23, the prayer portion, my lord.
And total accused number 1 is the company itself.
Company itself.
The complaint petition is now filed from accused number 2 to 9.
Correct.
Correct? Not
Correct.
1.
No.
Can you read the read prayer portion A?
Yes, so, paragraph. The entire thing, my lord?
Yes, yes.
Okay, in view of the above facts and circumstances, it is respectfully prayed that your honor would graciously be pleased to take cognizance of the offences committed under section 18A16, 18B, 18C of Drugs and Cosmetics Act 1942 and Drugs and Cosmetics Rules 1945 as amended. That the accused persons intentionally and knowingly committed an offence of manufacturing the not of standard quality drugs. In connivance of each other, they have violated a provision as laid down under section 16(1)(a) and committed offence under section 18A(1)(6), 18B, 18C and section 34 of Drugs and Cosmetics Act 1940 and liable to be proceeded against and punished
Michael.
under section 27D of the said act. In the aforesaid facts and circumstances and in view of cognizable offence committed them, it is therefore humbly
Flag
prayed
mark,
that your
section
honor may be
16,
graciously
section 18
pleased
and section 34.
to issue process against the above named accused persons, being number 2 to 9 under the relevant law, rules and provisions of Drugs and Cosmetics Act 1940. To issue process summons against the accused under section 32 of the Drugs and Cosmetics Act 1940 and the Drugs and Cosmetics Rules 1946 under section 16(1)(a), 18A.
So the violation is alleged against section 16,
16(1)(a),
A1A, 18A1,
Correct.
4, 18B, 18C
C
and
34
34.
of the Drugs and Cosmetics.
And this
Section 27.
the punishment is under section 27.
Correct.
Correct?
Yes.
So this person, when he had gone to, he had visited the office of the petitioner and he had drawn samples and thereafter he had sent them for test.
Correct.
It is then it has come into light that
Yes.
they are substandard.
That's what they are saying.
That is, that's right. I'm only trying to understand it.
Yes. In fact, my lord, I'll not press this point because once it goes for trial, this is one of the points
Correct,
we will
correct,
take.
correct, correct.
My lord, what has happened? My lord, as per the rule, my lord, the rule section, rule 25, when a sample has been sent, my lord, the report of the sample has to be returned within
Anyway,
60
we will
days.
not get into
We'll
all
not go in
that.
there, yes.
Anything more?
No, that's it, my lord. The punishment, my
My
lord,
lord,
is,
so,
I think,
my lord, so far petition number 4 and 6, my lord, prayer and a petition number 2 is they are from same family, my lord. My lord.
Mr. Mehdi, because they are from same family, whether vicarious liability can be fastened.
Oh, my lord, so my
You see, Mr.
submission-
Mehdi,
my-
the problem is you are not understanding the decision of the Supreme Court.
I understand, my lord.
So,
I understand.
you see, if you can show me that there are averments against these people, then of course I'm not going to, I will not even touch the complaint. But there is
so far-
nothing, apart from accused number 8 and 9, it's very general. It is only said that they are all responsible for
And-
day to day. Now,
and my-
how
and my-
are they responsible? What have they done? Nothing is there. Simply because they are
company-
directors.
Man, company is not before this honorable court.
No, company, we are not quashing the complaint against the company.
Yes,
The
ma'am.
trial will go on. The
Yes,
complaint is, I am not quashing the entire complaint. The complaint
ma'am.
only as regards accused number 2 to 7, perhaps. I am yet to dictate the judgment, which I am going to do it in some time now in the open court. Let me see how the flow goes. But prima
Yes.
facie, I think there is nothing to indicate that accused 2 to 7 has any active role. There's nothing. And you have not given any response to the decision of the apex court, which is heavily relied by learned counsel for the petitioner.
Yes, ma'am.
This is a case in the context of the Drugs and Cosmetics Act, where in
Yes,
relation to vicarious liability, the apex court has very clearly said mere statement that they are all directors, mere statement that they are responsible for day-to-day work is not sufficient.
Not every, but so far all documents is signed by the.
You see, Mr. Mehdi, you have to understand what documents have been signed. These are
Yes, madam.
authorization documents, is there any document showing that he has done something for the manufacturing, for the testing? There is no averment. He is a director, he may sign some document. Are directors, you see, is a director not entitled to sign a document?
No, my lord, I am not on that, my lord. I
Correct.
am
So,
on that,
so
my
that
lord.
is why I am saying, you see, you must have brought, you see, if you are saying that they are liable, there has to be something more to indicate. The complaint doesn't talk anything more. The complaint
That is true, my lord. That is true, my lord. Complaint on the.
correct.
but
So if that is true, you see, Mr.
the-
Mehdi, I am bound by the decision of the apex court.
Yes, yes,
Correct.
my lord. But I am trying to submit before this noble court, my lord. In complaint which was filed in court below, my lord, all annexures, my lord, it was, signature was signed by the Sandeep Bhatia itself, my lord. All related, my lord.
Now, what are these
So the-
annexures?
Annexures so far they are license related, renewal related. So far this just now I placed before this honorable court page 95 of the criminal petition itself. The date of responsibility given to one Rohit Sharma also. Everything is done by the Sandeep Bhatia, my lord. So he and this, so far these affidavit is also, my lord. There is only he says.
See, Mr. Mehdi, you see, the problem is that part of your submission is getting attracted, but you take it out of context. When you come to the affidavit and all, that will not help you.
No,
So
no,
don't
I'm
go
saying-
to that. Don't go to that. You are only confusing the court. 1 second. Mr. Joseph, these annexures,
Yes.
which are part of the complaint, these are what annexures?
My lord, these were documents which were collected by them. These are
For
basically
showing
tests.
what?
To show their test, to show the test of the drugs and things like that, my lord.
Now they are all bearing the signature of Bhatia.
My lord, that part I'm not entirely
Have
sure.
a look at it, because this is what is being submitted, because in that case we may not quash it for Bhatia. You see, Mr. Mehdi, I am trying to understand your
Yes, I know.
submission.
I
That
understand, I
annexure
understand.
part, you're right. But
Yes.
giving authorization, filing the affidavit, that has no relevance. Because you see, he is one of the accused, he is one of the director. Other accused may tell him that in the court we are authorizing you. So that will not attract the vicarious liability in a criminal offense.
I understand. I understand.
So
but
don't go
my-
to that. Don't
Yes,
go that
yes.
far. You stick
Yes.
to the main point.
Yes, my main point
You
is
want
that
you
all-
want
all-
to show from his involvement from the annexures, then plead that. Show me from the annexures. Because
Yes,
even
madam.
if you show me something a very minimum also showing he's involved, I'm not going to quash it. So show it, demonstrate it before the court.
Yes, my lord. So far, page 42, my lord. Page 42, my lord. Page 42, my lord.
Page 42 of what?
Criminal petition, my lord.
Yes.
This is the left, my lord, his signature, my lord. Sanjeev Bhatia, my lord.
Where is Sanjeev Bhatia's signature?
What is this? We have received and investigated the matter through BMR, BPR, all process parameters found as per given instruction, no deviation observed during process. Now we have checked and analysis, our retained sample and result are found within specified limits, but on behalf of your complaint. So this is after the complaint.
Yes.
How is it
I'm
relevant?
saying-
This is after
I'm
the complaint.
I'm just saying he is handling the everything, my lord. Yeah, my
See,
submission.
Mr. Mehdi, you have to understand. You see, post complaint, if you show me all this, is of no relevance.
Yes, my lord. But this license.
You have to show me that at that relevant point of time, he was the person. Which is your
Yes.
document? Show me that. There is
Well,
no
this is not-
averment. So show me from the document if you want to say.
Yes, my lord,
Page
this is-
42 is post complaint.
My lord, this which was not annexed, my lord, page, the annexure 15, my lord. It is not there, my lord. I'm just reading, my lord.
Page,
This is
page,
to-
page.
It is not there. It is not there, my lord. It is
Which
not there.
annexure?
It is this of my complaint file and report below. It is not there before your lordship, my lord.
Which is that annexure?
Annexure 15 of my complaint petition, my lord.
That's the annexure 15.
Mr. Joseph, annexure 15?
I will check, my lord.
I'm slowly reading, my lord.
1 second, before you read, where have you said that in your objection?
It is not there, my lord.
So you have not even said that in your
My lord,
objection.
this is the same one he had shown you, paragraph number 42. Page number 42, that is annexure 15.
Page number 42.
Yes, that is annexure 15.
Page number 42 is annexure 15. 12/5/22.
Yes,
That is annexure
that's
15.
annexure 15. And that too, my lord, this is a recall. They are recalling the drugs.
Yes, my lord, that is, yes.
Then,
Yes.
then what are you saying? All right, take down the order. Heard Mr. Joseph so-and-so, learned counsel appearing for the petitioner. Also heard Mr. S.K. Mehdi, learned counsel appearing for the respondents. All respondents, now?
One thing is, my lord, this I've just now seen, my lord.
One respondent.
My lord, in one annexure of my complaint petition, my lord, it is specifically written the Sanjeev Bhatia is the managing director, my lord.
Where?
Yes, my lord, in my form 26, my lord, form 26.
Where? Which page?
Friend may help, my lord.
Is he the managing director, Mr. Joseph?
No, he has never been mentioned as the managing director, my lord, to the best of my knowledge.
Form 26, my lord, this is not problem, not.
Page.
I'm trying to, my lord, please.
What do you mean you are trying to?
My lord, because he not annexed every documents, my lord.
He's annexed everything. You are only unnecessarily alleging. You don't even mention. If something is not there in the complaint, you should have brought it out in your objection. You don't say that in your objection. You are mentioning about page 42. Page 42 is there.
My lord, page 49, lordship, page 49. This is the investigation report done by them, my lord. Investigation report, page number 49. Now page...
Yes.
Page number 49, lordship will see towards the bottom.
Director.
Director.
No, my lord.
And then the next page as well, my lord, page number 50.
Where in 50?
Page number 50, my
Yeah.
lord, the next page immediately. There also again they have mentioned him as a director, Sanjeev Kumar.
Where in 50?
My lord, the top, on the top, right on the top.
Okay.
And then, my lord, your lordship will see towards the middle. This is lordship-
Responsible person.
Yes, Mr. Radheshyam and Mohan Singh. These are the accused persons number 8 and 9.
There are 8 and 9. What is this
QC's
part?
quality control. This is basically the investigation report. On this basis, they have filed a criminal complaint.
So this is the basis of the
This
complaint.
is the basis of the complaint.
This forms a part of the complaint.
This forms a part of the complaint, madam.
By way of this petition,
My lord,
I've heard you
form
enough,
20
Mr. Mehdi.
My lord, I'm sending form 26 of my complaint petition, my lord, to my lord. It is specifically written to the managing director.
I have
It
heard
is
you
there.
enough. Heard Kolu now. By way of this petition, under section 528 of the BNSS 2023, the petitioner is seeking quashing of criminal complaint stroke proceeding in criminal complaint number 119 of 2023 pending before the Court of Judicial Magistrate First Class 5, Aizawl District, Mizoram, against the accused appellants I 1 to 8. Okay, 1 to 8. The brief facts of the case is that the present appellants are accused persons numbers 2 to 9 in the said criminal complaint number 119 of 2023. By letter one second. Huh? Where is the complaint?
My lord, the complaint is at page number 60.
1
61.
61.
Yes.
Okay.
Starts from 60, but then the main content starts from 62.
The complainant, who is the drugs inspector under section 21 of the Drugs and Cosmetics Act 1940, hereinafter referred to as the Act, upon receiving sample manufactured by the accused company, Elgin Healthcare Limited, under a drugs manufacturing license, which is a drug which is drug of high therapeutic value used as gametocytocidal drug in P. falciparum infections to prevent transmission of falciparum malaria, particularly in area where there is potential for reintroduction of malaria by the Drug Controller General India, CDSCO, Directorate General of Health Service, New Delhi, page 63 pajama. Filed the instant complaint. Relevant paragraph of the complaint reads as under paragraph 4 or pra. Page 63 to 69. Accordingly, the complainant prayed sanctioning of prosecution against the accused petitioners along with the other co-accused with the following prayer, page 10, A to F. Mr. Joseph, so and so, learned counsel, appearing for the petitioner, submits that the accused petitioner number 229, who have been arraigned as accused in the criminal complaint under in the subject criminal complaint, are the directors. No, accused 227 ko ba, are the directors and have not been attributed with any specific role to play in the alleged commission of the offence under the Drugs and Cosmetic Act. He further submits that the allegation against the aforesaid accused petitioners are general in nature, and merely because they are directors and responsible for day-to-day control of business activity, they have been dragged in the criminal prosecution. He further submits that as regards accused petitioner number 8 and 9 are concerned, they are the person responsible for manufacturing of the subject batch of drug and testing of the drug respectively.
My lord, Can your lordship, yes.
Except the aforesaid description, no other specific involvement of the aforesaid two petitioners have also been alleged in the complaint.
No, my lord, it's okay. But my lord, with respect to 8 and 9, because they will be most probably subject to trial. So if your lordship could say something on the lines of they have been alleged or something like that.
I will.
Yes.
I'm only referring to what is there in the complaint.
Certainly, my lord.
I'll take care of that.
Yes,
Don't
my
worry.
lord, yes.
Huh? He accordingly submits that the present complaint ought not. No, he further submits. Where is the order of taking process?
My lord, that's at Roman page number 2. That's where it begins. Beginning, right in the beginning, my lord.
He accordingly submits that the order dated 2/6/2023, whereby the Court of Judicial Magistrate First Class Aizawl District, Aizawl, Mizoram, issued process, na?
Yes.
Took cognizance of the offence against the accused petitioners under section 27D of the Drugs and Cosmetics Act and issued summons thereof, is also mechanical and without any application of mind. In support of his aforesaid submissions, he relies upon the decision of the Apex Court in the case of Laran Kumar Singh and others versus State of Maharashtra, reported in 2023, volume 236, company case 741. Per contra, Mr. S.K. Methi, learned counsel appearing for the respondent, submits that it is evident from the complaint that the drugs manufactured by the accused company is of a substandard nature, is of a substandard quality, and the accused petitioners being the director and the person responsible for the day-to-day activities are responsible for manufacturing substandard quality. He further submits that the accused petitioner number 2, I. Sanjeev Kumar Bhatia, is actively involved in the day-to-day administration of the activity of the company, and in fact he is the person who has responded to the queries posed by the respondent authorities upon completion of at the investigation stage post filing of the complaint. He further submits that the accused petitioner number 2 is also the person who has been authorized by the other accused petitioners to submit on their behalf in the present criminal complaint. He also submits that the accused petitioner number 2 has also authorized one Joshua Lalrem Rwata Amma to sign, swear and file the rejoinder affidavit on his behalf by issuing an authorization letter dated 17/6/2025. He accordingly submits that the present contempt petition, the present complaint petition ought not to be entertained by the, He further submits that the complaint petition ought not to be quashed and set aside at the threshold by this court while exercising the power of quashing, inasmuch as prima facie an offence under the Act has been crystallized on the face of the averments made in the complaint against the accused company as well as the accused petitioners. All right?
Well, My lord, one thing I want to place, my lord, in my objection, my lord, in paragraph 14, my lord.
Yes?
I have stated, my lord, the accused number one, petitioner number 1, accused number 2, he is the managing director, my lord.
Where?
Paragraph 10, page 9 of my objection, my lord.
He further submits that paragraph
Paragraph 14, page 9 of my objection, my lord.
14.
Yes, my lord.
That petitioner number 1, I accuse petitioner number 1 is the Bhatia. So he
Yes, Madam, Sandeep
accused
Bhatia.
petitioner number 2 no hai, 1. Accused petitioner number 1 is the managing director of the petitioner company, whereas the accused petitioner numbers 2 to 6 are the directors of the said company, and the accused petitioner number 7 and 8 are the persons responsible for manufacturing and testing of the impugned batch of drug as per list of directors and constitution details of manufacturing license renewal provided to the joint inspection team, and all are responsible for the conduct of business of the farm.
My lord, for the interest of justice, my lord, I have sent the annexures, my lord, which I form 26, where it is indicated that he is the managing director to the court master, my lord, through his WhatsApp, my
Anything
lord.
has come? Just see. Next time, I'm not going to make such exception. I'm
Yes,
telling you,
sorry.
not in my court, Mr. Medhi. You want
Sorry,
to
ma'am,
rely
sorry.
on any document, you must
Sorry, ma'am.
plead
I
it,
understand.
and you must bring it to the court's attention prior to the hearing. You cannot take it for granted that all the matters listed before this court will be just adjourned. You have
Sorry,
some
madam. Sorry,
documents
sorry, madam.
which has certain bearing in the matter, you must bring it to record. This is not some living room drama going on. It's a constitutional court that you're appearing before.
Yes, my lord.
Can you take a print? Can you take it right now? Take 2 prints and give it one to the other side also.
Let me humbly point out, my lord, in his complaint, there is no annexure number 26 only. There is annexure only up to 19.
You just have a look
I'll
at the
have a look,
document and then you respond.
Yes, yes.
He further places an alleged Form 26, which is stated to have been part of the complaint petition, to buttress the point, buttress the argument as regards the petitioner number 1 being the managing director of the company. Pertinent that, yes, where is the complaint?
My lord, complaint starts from page number 60,
And where do we get the list of annexures?
74, my lord.
Annexure 19.
Annexure 19. Yes.
I have given my, you take a print and give it when you get it. It's pending in the library. I have given due consideration to the arguments advanced by the learned counsels appearing for the parties and have perused the materials available on record. I have also considered the case law cited at the bar. The present case being for quashing the complaint filed under section 200 of the CRPC, praying for taking cognizance of the alleged offence punishable under section 27D of the Drugs and Cosmetics Act against the accused persons, and for further praying for punishing them in accordance with law, comma. The test to be applied for exercising the power of quashing is well settled way back by the apex court in the case of Bhajanlal so and so. The said principles read as under, quote unquote, I think those 7 principles. 7, na, the principles?
I think so. I think something on those lines.
7 principles, huh? Keeping in mind the aforesaid principles, let me now look into the complaint. It is apparent from paragraph 5 and 6 of the complaint that the accused petitioner numbers 2 to 7 have been made accused in the criminal case only because they are the directors and alleged to have been responsible for day-to-day control of business activity of the company. There is not a whisper more as regards their involvement in the alleged offence. As regards the accused petitioner number 8 and 9 are concerned, it is stated at paragraph 6 that they are the person who are responsible for manufacturing of subject batch of drugs and responsible for testing of the drugs at the petitioner, at the accused company, respectively. Which section of the Act fastens vicarious liability?
Let me see, my lord.
At this stage, no, it is further apparent that the complaint has been registered under complaint is registered,
Complaint has been,
that order, na?
yes, that order.
Roman 2.
Section 34, my lord,
One second.
is the vicarious.
Where is 27D?
My lord, 27D is in the prayer portion.
Yes, but where is that in the Drugs and Cosmetics Act? I find 27 capital A. You have the Act.
I have portions of the act, but my lord, even I don't have the 27D. I'm
Yes.
sorry to say this, my lord.
Mr. Mehdi, it is 27A or D?
You know the D, my lord.
Huh?
D, my lord. Page 30, my lord, in my book, my lord.
In your book,
Page 30, my lord.
I have page 30, but it's 27 small d.
Small d, small d.
No, but is it 27 small d or 27? Because here it is written as 27 capital D. That is, there is no section 27D. There is section 27 A, B, C, D and section 27 capital A. Correct?
I think, my lord, has been amended. I think there is D.
You have
from
it?
online, yes.
You have it?
Yes.
Okay, then you say under it appears that the jurisdictional judicial magistrate has taken cognizance of the offence based on the aforesaid complaint under section 27 capital D of the Act against all the accused persons, including the accused petitioners. Relevant portion of the order reads as under quote unquote Roman 2. Accordingly, summons have also been issued. Section 27 capital D reads as under quote unquote. Section 34.
34, my lord. That is the vicarious liability. Offences by companies.
Section 34, which provides offences by companies, reads as under quote unquote. Reading of the aforesaid provision, it is evident that where an offence under this act has been committed by a company, every person who at the time of the offence was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company, shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly. However, such person shall not be liable to be punished if he is proved that if it is proved that the offence was committed without his knowledge, or that he exercised all due diligence to prevent the commission of such offence. Subsection 2 of section 34 further provides that where an offence under this act has been committed by a company and it is proved that the offence has been committed with the consent or connivance of or is attributable to any neglect on the part of any director, manager, secretary or other officer of the company, such director, manager, secretary or other official shall also be deemed to be guilty of that offence and shall be liable to be proceeded against and punished accordingly. The explanation to subsection 2 clarifies that company means a body corporate and includes a firm or other association of individuals, and director in relation to a firm means a partner in the firm. Apt at this stage, apposite koga. It is apposite at this stage to refer to the decision of the apex court in the case of Lalan Kumar Singh Supra, wherein the apex court has held as under quote unquote paragraph 16 to paragraph 30. You got it? Yes, what do you have to say to this Form 26?
My lord, I'm not sure this was part of the complaint in the first place, my lord.
No, but even if it's not part of the complaint, this appears constitution of the firm and it shows Sanjeev Bhatia as a managing director.
And this was of 2015, my lord. So I'm not sure if this has remained valid in the first place, my lord.
Right? This is of, the offense is of
This is of 2022, my lord.
2020.
22. And also, my lord, in their complaints also they have mentioned him as director.
No, opposite liquor. It appears that pursuant to an investigation report with regard to the drug reported to be not of standard quality and misbranded relating to manufactured by the accused company, the present complaint has been filed. The report dated, does the report has a date?
Yes.
Dated 11/9/24?
The report is of 2020. Sorry, the report is of 2023, 16/6/2023, my lord.
16,
6/20/22.
16/6/2022
Yes.
reads as under, quote unquote, page 49 to page 56.
Page 56, yes.
49 to page 56. The aforesaid report was forwarded by the Office of the Central Drug Standard Control Organization, Government of Assam, Government of India, to the Assistant Drug Controller by its letter dated 17/6/2022. Enclosing the joint inspection report dated 16/6/2022. A report to 16/6/2022. It is apparent, reading of the aforesaid investigation report, that the accused petitioner has been shown as a director of the petitioner of the accused company, and the accused petitioner number 8 and 9 have been shown as the person who are who were in charge person responsible for testing and manufacturing chemist. It further appears that the samples obtained from the accused company upon being tested were reported not of standard quality, with the remark within bracket, the sample does not conform to claim as per IP with respect to, within quotes, test for dissolution and assay of the primaquine by government, primaquine, first, full stop. It to me page 49 of the page. Though it is being vehemently contended by the learned counsel appearing for the respondent that the accused petitioner number 1 is the managing director of the petitioner of the accused company, however, there is not even a whisper to the same either in the complaint filed before the jurisdictional judicial magistrate. In fact, there is no document whatsoever to indicate before the jurisdictional judicial magistrate that the accused petitioner is the managing director at that relevant point of time. On the contrary, it is specifically mentioned. On the contrary, the accused petitioner number 1 is specifically mentioned as the director of the accused company. Though in the written objection filed by the petition by the respondent before this court, The respondent states as under, quote unquote, page number 9, para 14. Huh? Para 14, A to A. Do billion occupy, however, bill koi diba. It appears that except a bold averment in the written objection as regards the accused petitioner number 1 being the managing director, there has been nothing has been brought on record to substantiate the said stand before this court. It is pertinent that during the course of the hearing, the learned counsel for the respondent furnished a form 26 dated 9/9/2015 to show that the accused petitioner is a managing director of the accused company. However, the aforesaid form 26 is of 9/9/2015, much prior in time of the alleged offence in question. It is clear on record that at the time of the alleged offence during 2022, the accused petitioner number 1 is the director of the accused company as contended by the respondent themselves. It is evident from the decision of the apex court that merely because a person is a director of a company, it is not necessary that he is aware about the day-to-day functioning of the company. There is no universal rule that a director of a company is in charge of its everyday affairs. In order to fasten vicarious liability upon a director, it is imperative for the complainant to aver in the complaint as to how the director of the company was in charge of the day-to-day affairs of the company or responsible to the affairs of the company. Not a whisper is made in the complaint as regards how accused petitioner number 1 to 7 are involved in the day-to-day affairs of the company. It further appears that, however, as regards the accused petitioner number 8 and 9 are concerned, they are specifically averred to be the person responsible for testing and manufacturing. Hence, their case cannot be considered at par with the accused petitioner number 1 to 7. Another aspect which assumes significance in the matter is that the manner in which the jurisdictional judicial magistrate has taken cognizance of the criminal offence in question, alleged criminal offence in question. It appears that the jurisdictional magistrate has not applied its mind as regard the allegation made in the complaint against the accused petitioners. Undoubtedly, the jurisdictional magistrate is not expected to conduct a mini trial while issuing process and taking cognizance of a criminal offense. However, the judicial magistrate is expected to apply its mind on the face of the allegation so as to be prima facie satisfied as regards the as regards the commission of the offense alleged by the accused persons. In the present case, it is absolutely clear that the judicial magistrate has acted mechanically without any application of mind and took cognizance under section 27 capital D of the Act against the accused petitioners. That itself renders the order of the judicial magistrate illegal as far as it concerns the accused petitioner numbers 1 to 7, inasmuch as it is evident that there is no specific averment as regards their involvement in the alleged offense in the complaint petition. Hence, the complaint as far as accused petitioner number 1 to 7 is concerned stands set aside and quashed. The complaint petition as regards the other co-accused the trial in respect of the complaint as regards the other co-accused shall continue in accordance with law. Complaint petition stands dismissed.
Deeply obliged.
It is needless to be clarified that that any observations made herein is strictly for the disposal of the complaint for the quashing petition and shall have no bearing whatsoever while considering during the time of trial.
Deeply obliged.
Any case
My lord.
records have come? Any
My lord,
case
date, my lord.
records? Case records have come?
No, my lord, no, my lord.
And if stay order was there, na, Mr. Mehdi?
My lord, here not, my lord, they kept, in court below, it was kept in the abeyance, my lord.
Huh?
Court below, my lord, it kept in abeyance, my lord. Court below, my lord, there is no.
I think I have already said to continue, so that will clarify.
Yes, only my lord, date, my lord, one date may, my lord, date
It
may
is
fix, my lord.
needless to be clarified that the trial court shall conclude the trial expeditiously as possible.
Obliged, Lordship.
But for appearance, date, my lord, not.
That the trial court can give them a date. Why should I give a date?
Because
It is let the registry notify the trial court as regards the order passed today. Upon receipt of the same, the trial court shall fix a date of appearance for the accused petitioners, for the accused persons, so as to proceed with the trial from that stage.
highly obliged.
Can I take a 5-minute break?
Item 9.
I think AD card is still not received. Await service repost on such and such date.
9th of June. Item 10.
Yes, Mr. Lalfagwala, I think case records, trial court records have not come.
Not coming.
Not come, na? Call for await TCR. And what about service?
My lord, TCR copy is there.
TCR is
Photocopy.
there?
Yes.
Scan copy.
Photocopy is there.
What about service?
I'm representing the respondent.
All.
No, the single. Sole respondent.
So then what is to be done?
It's for hearing, my lord.
Hearing.
Your Lordship, I'm appearing on behalf of my senior, Mr. Cesar Msana. My senior is on leg on court number 1,
That's all right. Your name?
Isaac Lalrambuata.
Heard Mr. So-and-so, learned counsel appearing for the petitioner. Also heard Mr. C. Lal Faxwala, learned counsel appearing for the sole respondent. Upon the appearance of Mr. Lal Faxwala, learned counsel for the sole respondent, service in respect of the respondent stands complete. It is further brought to the notice of the court that the scanned copy of the case records have already been received. The matter is ready for hearing. It's already admitted.
I think this is for admission hearing, my lord, if I'm not mistaken. I think it's for admission hearing. It has to be for
Let the
admission.
matter be. For today only it has come for admission.
We have already filed a written objection, my lord.
As prayed for repost on such and such date for admission.
11th June.
Obliged.
Item 11.
Yes, Miss Mary, who's appearing for the petitioner?
Your Lordship, they are outstation advocate, but Your Lordship, I would like to submit that on 21st January 2026, they did not appear. And the matter was listed again on 17/2/2026. And again on 17/3/2026, they did not appear, so they are not diligent enough.
See, it's a criminal complaint.
Here, there.
Yes, Mr. Nag, you're appearing.
Yes, I'm appealing for the appellant. Lordship, I'm very sorry that I'm out of station.
Appellant, this is a criminal complaint petition.
For the petitioner, Lordship.
Yes.
Court for Hanover.
Where is
Lordship,
your
in this-
court?
I'm very sorry, Lordship. Actually, yesterday night I have to come to my native place at Tinsukia. And at night only I got to know that the case is listed.
No, but you are
So-
not appropriately dressed also to address the court.
Lordship, I have to seek a slight adjournment today, Lordship.
This is not appreciated, Mr. Counsel. And why are you not having a local counsel? You must engage local counsels also. There is no difficulty for you to appear in video conferencing mode from a remote area, but you must, whenever matters are, you are engaged in matters which are out of your jurisdiction, you must have some local counsel because it helps the logistics.
Yes, Lordship, we had a
There are so
local
many
counsel.
competent lawyers at Aizawl bench. Why are you
Absolutely.
not engaging someone
Absolutely.
from here?
Absolutely, Lordship, that's my mistake. We had a
Because
local counsel.
not only that, I find on 2-3 occasions there has also been no representation on the petitioner side.
Lordship, that was technical error. as
Whatever
I-
be it, Mr. Counsel, you please engage someone from here also.
Lordship,
This can't go on like this. You cannot just
Lord-
choose not to appear and then appear one day, that also in not proper attire. These kind of things cannot be appreciated by the constitution courts.
Lordship,
Please take care of it.
Lordship.
Heard Mr. Saurav Nag, Learned Counsel, who is appearing through video conferencing mode. Also heard MS Mary. You're appearing as
The
APP,
additional public
Learned
prosecutor.
APP for the state respondent. You are appearing.
Yes, Lordship. I'm appearing on behalf of my senior, Mr. Chodiato.
Your name,
Len Mangaisanga.
Mr. So and so, Learned Counsel, appearing for respondent number?
2.
Respondent number 2. You're appearing on behalf of Johnny.
Yes, Lordship.
On behalf of Mr. Johnny L. Toswang, Learned Counsel for respondent number 2. Mr. Nag, Learned Counsel, who seeks a short accommodation as he is, as he's not able to, as he's not in his office today and is in a remote location from where he has joined the hearing through video conferencing and is not, and also does not have the brief of the matter. In view of the aforesaid, released on such and such date.
1st of June.
Mr. Nag, you please ask your client to engage someone here also. I do not like such kind of conduct because 2-3 occasions there has been no representation. Yes, next matter.
Item 12.
Defreezing bank, Mr. Victor.
Yes, my lord. In terms of the last court order 19
Who freezed your account?
by the Bank of IndusInd Bank.
Yes, ma'am.
Yes, Your Lordship, we have complied with the last order and have defreezed the
complied?
account.
What is to be done?
My lord, in this case, the sum of about rupees 3 lakhs is still kept on lien. And there are no...
That is the disputed amount.
Yes, my lord. But my lord, till date, there is no FIR investigation or that the investigation agency have also not intimated
So
to
I'll
the...
put it for hearing.
Yes, my lord, that is
Pleadings are complete.
complete.
Heard Mr. Victor L. Lalte, Learned Counsel appearing for the petitioner. Also heard MS.
Sarah Lalvensangi.
Sara Lalvengsangi, Learned Counsel appearing for the respondent number
1.
Respondent number 1. It appears that pursuant to the order dated 19/2/2026, the respondent number 1 has defreezed the bank account of the petitioner by keeping the disputed amount I-306107 on lien. Mr. Victor L. Lalte, on instruction, submits that the petitioner is accordingly operating the said account, isn't it?
Yes, my lord.
In terms of the last court's order. Since pleadings are complete, let the matter be posted for hearing on such and such date.
8th of June.
Sorry, admit korbo লাগিব নেকি? Since the matter involves full-fledged hearing, let the matter be admitted. No formal notice as parties are represented. Post for hearing on such and such date.
Deeply obliged.
Item 13.
Item 30. 1-3.
Yes, may please, Your
So this is
Lordship.
again freezing.
Yes, my lord. But my lord, in this case, the petitioner shall be appearing in person, Mr. Lasoy Rema. But due to some personal difficulties, he could not appear today.
As prayed for by MS
Miss Rosie
Malantangi, Learned Counsel appearing on behalf of the petitioner to the effect that the petitioner who is appearing in person could not be present before this court due to personal difficulty. Let the matter be posted on such and such date.
2nd of June.
Deeply obliged.
Item 14.
Yes, I think case records have not come.
Yes, madam.
Await TCR repost on such and such date. Then reminder.
11th of June. Item 15.
Yes, Miss Fanai, ground of arrest.
Yes, my lord.
Ground of arrest.
Yes, ma'am.
Not given.
My lord, yes, it's not given. It was given to, my lord, it was given to one person, but however, she was in the seized vehicle.
She was in the
seized vehicle.
So how many accused are here?
Just one.
Huh?
Just one.
Right now, this is one accused.
Yes. We are the only accused.
You are the only accused.
Yes, my lord.
And to you, the ground of arrest is given or not given?
Not given.
Not given.
Not given to my relatives.
And to you?
It was on records. It was said it was given to one person, one lady, who is with me at the time of arrest. She was in the vehicle.
But
she
she's
was my
not you.
passenger.
She's not you.
Yes, she's not.
And is she related to you?
Yeah, not related, not a close relative. I'm not living with her.
Yes, Ms. Bani, what about the violation of Article 22(1) that has been alleged here, that they are alleging?
Your Lordship, as we can see from the record,
Yes.
it has
Records, you mean these ones?
Yes, grounds of arrest has been given to the accused.
Where do we get?
I flapped it, Your Lordship. Yeah.
My lord, at page 18.
Page?
Of my 18 of my application. (18, 19) and 18, 19.
Yes.
Here, the grounds of arrest has been given to the accused.
Where is the ground of arrest?
Page 17 of the petition.
Yes, 17. What is the ground?
Ground is
What is the ground?
committed offense under section 21B.
That's not ground. That's not ground. Ground is that facts constituting the offense. Where are the facts? This is not in tune of the apex court judgments. So many judgments even this court has authored on this point. You see, the grounds have to be given in writing. Committing an offense under so and so act is not sufficient. What are the facts constituting those grounds? Where are those? Yes, this is what Behan Kumar Purkasta. What is that latest decision?
Mihir Rajesh.
No, there's one more. You're not carrying it.
No,
How come? You are the petitioner, Miss Fanai.
yes, my lord, I have some personal health problem. That's why.
Oh, okay.
Even yesterday we had prayed for adjournment.
You're not well today?
I'm not very well, but however, my lord, I can try for the hearing.
So this is the only document to show.
Yes, Your Lordship, and it is stated that he is possessing suspected heroin.
Where is it said? Possessing.
Yes. Upon the reliable information received by me that you have committed offense under section 21B of NDPS Act, so and so possessing, transporting suspected heroin.
This is there.
And here it is stated.
Fanai, I think this is sufficient. You have any other grounds?
Yes, my lord, we have.
Are you comfortable in doing it today or you want an accommodation? You see, as far as your Article 22(2) is concerned, page 17 is the answer.
Yes,
The grounds have been given. These are
Also-
sufficient.
Also, my lord, it's not given in the vernaculars, which we don't even understand.
You have signed it in English.
But the Mizo script it looks like English, but it's totally different.
Which is the decision which says that vernacular also has to be given?
That, my lord, I will produce it.
So you give me.
Yes, my lord.
When do you want it?
My lord, if possible on Friday.
This
If
Friday?
Yes, my lord. If the learned PP. My name.
I think in Mihir also it is mentioned in a language which the accused understands.
Yes, my lord.
But all that, have you stated here or not?
Yes, my lord, I have stated.
You have to show that you don't understand. This has to come out.
Yes, my lord.
Because prima facie, it appears that the ground of arrest has been communicated in writing. The fact that you do not understand English, you have to, because you have, at the end of the day, you have to show that you're being prejudiced. If there are documents to show that you know English because the signature is in English.
Yes, my lord.
Okay, you think over it. Subsequently kita lage Pranav. You look into the latest decisions, Ms. Fanai?
Yes, my lord.
As prayed for by MS Fanai, learned counsel appearing for the petitioner, which is not opposed by MS Vani, learned APP for the state respondent. Repost on Friday. Huh? When so.
22nd May.
It's 1 o'clock.
Lordship,
Yes, Mr. Lalram Zava.
sorry to interrupt. Lordship, I have one VC to attend at 2. My item here is 17. So my item
17.
17.
I think some written objection was required in 17.
That has been filed.
I
Yes.
already, I am for respondent number 1 to 3, I already filed.
Today?
If I don't know it. 13 filed.
Yes, I know. Who is supposed to file?
And Your Lordship, I am representing respondent 4 to 7.
7. Have you filed it?
No, Your Lordship, we will not be filing.
You will not file.
Yes, Your Lordship.
And okay. So then I will have it on another date.
Yes.
I heard Mr. Lalram Zwaba, Learned Senior Counsel, assisted by Mr.
Steve.
Stephen, na?
Yes.
Mr. Stephen, Learned Counsel for the petitioner. Also heard MS Zangpui, Learned Counsel, appearing for respondent number
1 to 3.
1 to 3. MS Vani, respondent number
4 to 7.
4 to 7. Anyone else? It appears that the written objections on behalf of respondent number
1 to 3.
1 to 3 is already on record. However, Ms. Vani submits on instruction that no written objection would be filed on behalf of respondent number 7.
4 to 7.
4 to 7. Let the matter be placed for
Lordship, we may like to file a reply also.
then you say Mr. So-and-so seeks a short accommodation to file reply against the written objection filed by the respondent number 1, 2, 3. Prayer is allowed. Repost on such and such date.
2nd of June.
All right.
All right. Okay.
Matters pertaining to the principalcy for admission, item numbers 1 and 2.
Yes, Mr. Kaushik.
Lordship,
The two UN sanction lists that both parties have given, as far as the one which has been given from the petitioner side, you say that Iran is not in that list, right?
Lordship,
But I find Iran is there. Mr. Borderline,
Lordship.
have you received the list given by the petitioner side?
No, Your Lordship.
Mr. Kaushik,
Lordship,
I find in your list also, at several places Iran has been mentioned. Say for instance, do you have the documents?
yes, Your Lordship.
You come to there's no page numbers, but it says one Ali Akbar, nationality is Iran.
Lordship, Lordship, as a country, Iran is not mentioned. Only people from Iran and other things are mentioned, but as a country,
But then, Mr. Kaushik, what about this which is available in the at the website, the UN sanctioned countries? Iran is mentioned as one. This is given by the respondent, and even this court has also independently found this in the found it online. Here, Iran seems to be an UN sanctioned. Which countries are currently on the UN sanctioned list? Iran figures to be one of them.
Lordship, I have not received the document, Lordship.
Mr. Bordelais, why don't you exchange that?
Yes, Your Lordship.
Give him a copy.
Lordship.
Mr. Kaushik, you have a look at it, because even this court has found it online.
Lordship, the document which we gave you, Lordship.
Yes.
It was from the in the affidavit in reply we have annexed the master direction, Lordship.
That's
in
all
there,
right. That's all
a
right.
link is given, Lordship.
See, Mr. Kaushik, that is one thing. Now, in the RBI thing also, it is mentioned as the UN sanctioned countries, correct? So, your first argument of Dr. Saraf was that Iran is not in the UN sanctioned list. And
Lordship.
therefore, it doesn't come within the Indian regulatory system. So, ICICI Bank need not restrict the movement of any, is not under any obligation to restrict that transaction, correct?
Lordship.
That was the submission of Dr. Saraf. Now,
Lordship.
even if you do a online search, you can do it right now in your mobile. You can just type UN sanctions list. Just type it. Which countries are currently on the UN sanction list? You got it?
Lordship, I am trying to search, Lordship.
I think it will come. Just see, Mr. Borderline.
Yes, sir. Which countries are currently under UN sanctions is Iran plus.
See, because this is something disturbing, because it seems that Iran is there. So you find it out. Mr. Kaushik, I'll give you the time.
Lordship.
You look into it, because this, as per the information available in the net, Iran seems to be one of the country, okay?
Lordship, we have to verify this.
You
Lordship.
verify. I am not closing it. But Mr. Borderline, now the bigger hustle, the hurdle which I have for you, Mr. Borderline.
Lordship.
See, whether Iran is in the UN list, whether Iran is not in the UN list, this is another aspect.
Lordship.
Now, a huge amount of money of the petitioner you are dealing with, correct?
Yes, yes, Your Honor.
And it is undisputed that this entire money, it was US dollar of how much? 40 lakhs?
Around 40 lakhs, Your Honor.
Around 40 lakhs. Was given to you
Right, sir.
by the petitioner,
Right.
which you have kept it.
Yes, Your Honor.
Correct? This money is meant for the petitioner
Yes, sir.
against the supply.
Right, sir.
Now, you may have a lot of reasoning for doing it, but these are drastic measures.
Right, sir.
Now, before you adopt or resort to such drastic measures, are you not entitled, is the petitioner not entitled for a hearing? You are a bank, but
Yes, sir.
you should have given them more clarity. You should have asked for opportunities, clarification.
Right.
You have simply blocked the account. You have blocked blocked the money. And
In
there
fact,
is,
Your Lordship,
and hear me out, Mr. Borderline.
What?
And you see, there are no straight restriction also there in your regulatory framework. The RBI and all, these are all now interpretations that you are trying to show.
Right, sir.
Correct. In fact, Dr. Saraf's argument is that there is nothing in the Indian regulatory system which restrict the Iranian vassals' transactions.
Right.
But it is only in the US sanction, which the Indian bank could not have followed.
Right, sir.
Now, if you try to make out a case that yes, you are liable by the foreign law, which you may be,
Right, sir. Otherwise, because
which
of
you may
this-
be, I am not going into all that aspect, but what I am is as a writ court, I am also going to examine the decision making process.
Right, sir.
Now, decision making process means you have to act fairly,
Yes, sir.
correct?
Yes, sir.
To be in a transparent manner.
Right.
Now, where is the transparency, you tell me, Mr. Borderline?
That
Where
has
is the
not been-
fairness? Where
That
have
has
you
not
given
been
the
done.
opportunity to the petitioner?
Yes, sir.
You see, these are the questions that are coming to the mind of the court.
Yes, sir.
I am also privy that one of your major ground is that the writ itself is not maintainable.
Right, sir.
But then for that federal, the decision on Shobha and federal are the answers. At the end of the day, the functional test has to be applied by the court.
Right.
Now here, you cannot simply say that it is a purely commercial transaction. There are certain statutes involved, there are statutory duties. In fact,
Yes.
your whole case is that as per the law you have restricted it. Now if that be so, you have to candidly show that this is the law, this is the law of the country. But you are not being able to show that.
Yes, sir.
You are showing me something of the corresponding bank, the foreign law,
JP Morgan. was
JB
also-
Morgan. So various things are not very clear.
Right.
So I'm going to keep this matter on another date,
Right.
but I'm expressing the anxiety in the mind of the court. I am not sure what I will do. There is a possibility that I might remit the matter back to the respondent bank
Right.
to give an opportunity to the other side
Right.
and then take up the step in accordance with law.
Right.
That is only a possibility. Mr. Kaushik,
Lordship,
this could be a possibility. I am not saying I'm going to do that. I am indicating a possibility. So you both can go back to your chambers and speak to your seniors, and we can have the matter next week on Tuesday.
not your lordship.
In the meantime, Mr. Kaushik, you please verify the
Yes,
UN
yes,
sanction
yes, your
list. Whether Iran is a country or not in that sanction
Yes, your
list.
lordship.
Okay? Because the list you gave me also indicates that there are few people from Iran. You are right, those are individuals.
People from Iran are
Correct, correct. But you see, those are individuals of Iran origin. So apparently the country could be also in the sanction list. So
Lordship will verify.
you verified.
Lordship will apprise your Lordship. Of
Very well. So shall I keep it on next Tuesday at 2 o'clock?
Lordship.
All right.
Then-
Heard Mr. A. Kaushik, na?
Yes, your Lordship.
A. Kaushik for the petitioner, also heard Mr. G. Bordoloi and Mr. So and so, learned counsel appearing for the respondent. The matter is posted again for further hearing on such and such date at 2 p.m. through video conferencing mode.
26th May.
Highly obliged, your Lordship.
All right.
Aizawl bench, item number 16.
Next, your Lordship.
26.
This goes with this, huh? Dina, put this back in my chamber. This is item number
16.
16. Yes, Mr. Ahmed, are you appearing?
Yes, Lordship.
Ms.
Here
Linda?
in this case, the petitioner was arrested on 1/3/2026. And
Dina. Go to my chamber. I think, Michael, you may have to go. There are 3 decisions. I have put a blind small clip on the ground of arrest. I have it in hand. Yes.
Here, Lordship, I am seeking bail on 2 counts. First is that he was detained more than 24 hours, which violates his constitutional right, that is Article 22(2).
Yes.
And second count is that, Lordship, that 48 notice was not served to his family members in writing.
What was not given?
48 notice.
48 notice.
48 BNSS notice.
40.
Yeah, 48, Lordship, to the family members.
DNS.
Notice to the family members.
DNS.
Lordship.
Is that mandatory?
Lordship.
It's a mandatory or
Your
it's
Lordship.
only a
Yes,
procedural?
your Lordship, division bench judgment is also there.
Hmm.
That in Nia case, your Lordship held that even
This is a Nia case?
not be, Lordship.
And what about that 24 hours? You have something to show?
Yes, Lordship. Lordship, may kindly have a look at page 23.
Yes.
First paragraph, your Lordship will see that in last line of that paragraph, intercepted at around 6:20 a.m. on 1/3/2026.
Where, Mr. Ahmed?
Page 23, first paragraph, top, Lordship. Starts with, I have the honor
Yes,
to
yes,
state
yes,
that
yes, yes. Yes. 6:20 a.m. on 1/3/26, yes.
Yes. And forwarding report I have annexed, Lordship, that is 34-1, page 34-1. He was forwarded on, Lordship, 2/3/2026.
34?
And on 2/1, Roman 1, within bracket Roman 1.
I'm not getting it.
After rejection order, that was annexed, Lordship.
Page 34?
Yes, Lord. 34 Roman 1. After the rejection order, that subsequent.
No, it's not there. Where is it? There is nothing like
there-
Roman 1.
It was inadvertently, it could not be annexed, or subsequently defect was there, so it was.
No, but
one,
where is it? It is not here. See, the problem, I don't know, there was another matter in the first half. You people are not engaging any local council here.
Local council is there, Lord.
Where is your local council? He's not in the court. There's no local council in the court for you. See, you are saying there is something which was inadvertently not there in the bail application, subsequently it is there. I don't find anything here. There's nothing here. I'll have it on another date. You contact your local council.
Lordship.
Heard Mr. A. Ahmed, Leonard Council.
My lord, even my copy has no pagination, so it's difficult.
The PP's brief has no designation. What is this, Mr. Ahmed?
But sir, I will contact my
No,
local
but
council.
this is not the way
I will give a fresh copy.
the matters in the constitutional court are presented. If copies are served to the PP, it has to be properly marked. The PP has to assess the court. How do you expect the PP to assess the court when the matter is taken up for hearing if the paginations are not there? This is not fair. This is not fair to the PP, to the court, and it is also not fair to the learned PP. You rectify all this.
Lordship.
Heard Mr. A. Ahmed, Learned Counsel, appearing for the petitioner. It appears that the annexure sought to be relied by the Learned Counsel appearing on through virtual video conferencing mode is not available on record. It is further brought to the notice of this court that the bail application served to the office of the learned PP is not paginated. The manner in which the case is being conducted before this bench is totally depreciated. Let the bail application of the learned PP be paginated, repost on such and such date.
25th of May.
All right.
Item numbers 18 and 19.
Lordship, as per last court's order, the pleadings are completed, and if this
So
may be
we'll
listed-
fix it for hearing.
Yes, Lordship. If
heard-
date may be fixed, my lord.
Huh?
If date may be fixed.
Sorry?
If date may be fixed.
Yes, Ms. Ruth, I am going to fix a date. In fact, the first instruction I gave it to Mr. Michael in the morning is that in all matters in my court should have a date fixed. Heard MS?
The Ropari.
Lal
Ropari.
Ropari.
Yes, Lordship.
Learned Counsel appearing for the petitioner, also no, appellant. Also heard MS Ruth Lal Rutfali, Feli. Learned Counsel appearing for the respondent. It appears that the trial court records have been received. The matter is ready for hearing. Repost on such and such date for hearing.
4th of June.
Obliged. Yeah.
Item 20.
21 days delay. Mr. Lalfaghzwala. Is anybody appearing?
Yes, Lordship, I'm appearing on behalf of the respondent number 1.
What about?
DNIA.
Respondent number 2 is the employer of the deceased.
Dusty, you were allowed.
Yes.
Did you take? Affidavit of service is fixed. The affidavit of Dusty showing proof of service is filed. So we can condone.
Yes, Lordship.
Mr. Lalfaghzwala, any objection for condemnation? Heard Mr. Lalfaghzwala, Learned Counsel appearing for the applicant. Also heard MS
The Ropari.
Lal Ropali. Lal Ropari.
Yes,
Learned Counsel appearing for respondent number 1. As per the affidavit of service of filed on 16/3/2026, it appears that service in respect of respondent number 2 is complete by Dusty. By Dusty mode, huh? By way of this interlocutory application, the applicant is seeking condonation of a delay of 21 days in filing an appeal against the impugned judgment and order dated 19/5/2025 passed by the Learned Commissioner Employees Compensation (ISOL) in EC case number 10 of 2023. The grounds of delay reads as under Roman 1 to 7, 1 to 9, page 4 to 7. Mr. Lal Fagswala, Learned Counsel, appearing for the applicant, submits that the reasons for the delay are bona fide and unintentional. He submits that the applicants are not negligent in pursuing their case. MS so-and-so, Learned Counsel for the respondent, fairly submits that she has received no instruction to oppose the prayer for condonation. Having heard the learned counsels appearing for the parties and having perused the reasons for delay, I do not find the grounds urged I find that the grounds are sufficient and bona fide. Accordingly, delay stands condoned. What about the connected MA? It is registered.
Yes, Lordship.
Yes, already registered.
So we can admit it.
Yes, my lord.
Can you give me employer's compensation? To dispose of query. Substantial question of law has to be there.
Yes, my lord.
So I'll issue notice
Yes, Lordship.
today.
We have also framed, my lord.
Where is it?
Page 34 of my appeal petition, my lord.
Page
34.
All right, we'll have it fixed on another date
My lord.
for considering. Okay,
Yes, my lord.
Lordship, in the meantime, if copy can be given to us.
that's right. So I'll issue notice so that in the appeal you say issue notice. Let a copy of the appeal be furnished to so and so. You're accepting for whom?
Respondent number 1.
One or number 2. Number 2, what do you want to do? Fresh steps?
My lord will take fresh steps.
Fresh steps number 2. After 3 weeks.
11th of June.
Much obliged.
Right.
Item 21.
Yes, Mr. Silo, 43 days.
About 3 days, Your Lordship, and I have consulted with my learned friend, and she will not be opposing.
Lordship, yes.
He is convinced you not
Yes,
to
he has
oppose.
already convinced me. I wouldn't be filing any objection to the condonation of delay.
I'll condone it then. Mac appeal.
Back appeal, yes.
Heard Mr. Jonathan L. Silo, Learned Counsel, appearing for the applicant. Also heard MS Mal
H. Lalmal Som.
Malswam Tungi Raute, na?
No, Your Lordship. H. Lalmal Som.
Oh, okay, sorry. Lalmang Swangi. H. Lalmang Swami. For respondent number 1 to 3, right?
Yes, Your Lordship.
By way of this application, the applicant is seeking condonation of delay of 43 days in filing the connected appeal assailing the judgment and award dated 21/7/2025 passed by the learned member cum presiding officer MACT Aizol in MACT case number 37 of 2025 under section so and so of the MACT Act likhi diba appeal par sale while filing the connected appeal, a delay of 90 days having occurred, the present, while connecting, a delay of 43 days having occurred, the present condonation application has been filed. The grounds of delay reads as under paragraph 3. Mr. So-and-so submits that the delay is totally unintentional and beyond the control of the applicant and accordingly seeks condonation of the same. MS so-and-so, learned counsel for the respondent, fairly submits that she has received no instructions to oppose the prayer for condonation. Having heard the learned counsels appearing for the parties and having perused the reasons stated in the condonation application in support of the prayer for condonation, the grounds appears to be bona fide and sufficient. Accordingly, delay stands condoned. Disposed of. Have you deposited the 25,000? Appeal admit. Call for case records. You are accepting for whom?
I'm accepting notice on behalf of respondent number 1 to 3.
1 to
3 number.
1 to 3 and the remaining by speed post GD Bolaga within 3 days.
16 of June.
It will report appeal under
Item numbers 22 and 23.
Slowly. What happened? Yes, you caused a disaster.
It's quite voluminous.
Huh? Yes. Quite a voluminous regular second appeal. First appeal.
Yes, my lord. RFA 10 of 2013 and 11 of 2013.
Yes.
For the purpose of convenience, my lords, I will be referring RFA 10. It's more or less, the nature is similar, my lord.
Yes. Just being a CPC. Yes.
Before going through the reports, my lord, I will just give a gist of the case.
Yes, yes.
My lords, what happened is that
Miss Caroline, you are appearing.
Yes, my lord.
the state government has floated a tender. Then I have participated. The works is for construction of Greater Sership Water Supply Scheme. That is under the PHE department. Then I have completed the works. The scheme was also commissioned. Then it's operational. Then what happened is that my main grievance is that I had submitted my...
In short, your name is Lima.
Tlana.
But the last...
Yes, Tlan Tiang Lima.
Huh?
Tlan Tiang Lima.
Han?
Tlan Tiang Lima.
I don't know. I know you by face, but I'm always having difficulty in pronouncing your name. So what is the shortest version of your name?
Tlana.
Give it to me.
Tlana.
Tlana.
Yes, my lord.
Tlana.
My lord. Okay.
Yes, Mr. Tlana.
So the water supply scheme was commissioned and it's operational. But my main grievance is that in the contract agreement signed between me and the department, there was a clause for interest. Subsequent to my submission of the bill, if the bill is delayed by 30 days after my submission,
then it will carry 2% interest. Now that is disputed by the said respondent.
You were who? You were the supplier.
I'm the contractor,
You are the contractor.
my lord.
You have done what?
I've constructed the Greater Sership Water Supply Scheme
Okay.
under the PHE department,
Okay, so the respondent is the PHE.
my lord.
The dispute relates to the interest.
Interest. The admitted liability have been paid, but this particular case relates to the interest.
Under the contract, interest is there.
Yes, my lord. But they are disputing that. They are saying that the interest clause is not there in the contract. But I am saying that it's in the contract.
The trial court says it is not there.
Trial court says it is not there, my lord.
Okay. All right. How come your brief is small?
Mine is divided into many parts, my lord. I've divided into
Oh, why? You should have done the same for the court's convenience. It is so difficult to handle this brief. I was in the other side, I remember in matters of such volume, we generally used to provide spiral binding in different parts, in chunks for the assistance of the court. That should be the practice actually.
my lord.
It became easier, you see, because this is very big.
Yes.
Nothing otherwise. It's just that it's inconvenient to once you see you have to go through all
Yes,
the pages.
I'll go here and there.
Yes. So this is very difficult. Anyway. Yes.
I think that can be done also, my lords, if for the convenience of my lords.
I think it would be.
Yes, because I now the
When can you give it?
it's more than 900 pages, so I don't know how long will it take, but
Anyway, let's start.
yes, we
Let's see.
shall I start from my evidence or my lords?
One second.
Shall I?
Yes, I think that will be better. Yes. Remove this, didn't I? Should be better. Yes. Yes, Mr.
Page 12, my
Plana.
lord. Page 12.
Page.
Page 12 of the paper book. This is the contract agreement.
Yes.
Yes. And there in the next page, my lord, in page 13,
Yes.
it states that the further terms, conditions, and covenants of the contract are set forth in the enclosed sheets, each of which are attached hereto.
Yes.
Now, this is one of my standard. The details of the interest and all are all contained in the contract agreement.
Where
So,
is
if my lords will see the page 45.
Yes.
Now, what I'm saying is that these are all parts of the contract agreement. If my lords will see at the top, it says that commercial terms and conditions.
Yes.
And at the bottom, if my lords will see the seal of the PHE department, the chief engineer is also contained there. And
Yes.
the seal of the contractor, Johnson Eastern Power, is also contained.
Yes.
And if my lords will see at page 55, this is still under the commercial terms and conditions. Page 55.
Yes.
Yes, my lord, the pricing is there.
Yes.
Under in the third line, my lord. So I want to read the second portion of the pricing, second paragraph under the pricing.
Yes.
Should you not be able to make payment for reasons beyond your control in time, we shall have the right and liberty to charge you due compensation, and you will have to pay us such compensation within a period of 1 month from the date of such claim. Compensation is to be paid at the rate of 2% per month of the amount of money blocked by you. Now, this very document was exhibited as Exhibit P2.
Who is you?
Means the department.
From where do we get? We have priced our work on the consideration that timely payment. We means you.
Yes.
So where do we get all this?
Here it means that, my lord, upon submission of our bills, if 30 days
So
delay.
this is this starts from page 53, I think. 5, 4, 3.
No, my lord, it's all, it starts from.
No, because you see there are internal pages also 1, 2,
Yes,
6.
yes. It starts from page 45 actually. This is
Now,
under
how
the.
do we know? Because page 52 is some tender in compliance with this. We are enclosing the special term deposit. Then comes general terms and conditions.
Yes.
They must be disputing this.
Yes, they are disputing this portion, my lord. The pricing portion they are disputing. But this whole document
Mr.
was.
Klana,
Yes.
prima facie, even this quote is not very much with you. No, because you see the way the pages are.
These are.
You see, if it's a continuous page,
Yes.
there's no difficulty. You are saying page 55 is a part of page 12. Correct?
It all continues, my lord.
Correct.
Yes.
Now, so then there has to be a continuity, no? Now, if you see page 12 is some contract agreement. Okay. Then page 14 is some letter. These are all interest bills.
Yes.
Then finally, page 23 is some notice. How can it be continuity?
I will come to that, my lord.
From where does it continue? The contract agreement then is at page 40.
If my lords will see page 40.
40 is an agreement.
Yes, this is the contract agreement.
Very well. Now the contract agreement ends in page
41.
49. It ends at page 49. After 49, I don't know what are these. 49 is the contents.
Yes, my lord. After 49, it's still continuing, my lord.
No. On what basis?
These are all the commercial terms and conditions, my
No,
lord.
on what basis
I
you
will
are
come to
saying?
that, my lord.
Because you see, the earlier pages is a part of an agreement. It's in a it is some stamp paper. Now page 50 is some commercial terms and conditions.
Yes. What I'm saying is that, my lords, the commercial terms and conditions is all part of the contract agreement. Because, my lords, in the exhibit, at the time of exhibiting these documents, my lords, if my lords will come to page 896, my lords, this is the evidence of the plaintiff, the appellant.
1 second. No, you have to, if you want your case to be, if you want to buttress your point home, then Kliana, at page 49, you have to individually mark the pages of item 5, 6, 7, 8, 9, 10. Where do we get those pages?
This was not done.
Then it has to be done.
But my case is that, my lords, these are.
See, it's not about you saying it from record. It has to appear so. Now you are trying to show that those pages are part of it.
Yes.
It has to come up because it's a dispute. They are disputing it. if page 50 is part of page 49, then there has to be specifications also somewhere. And this page, at page 49, it starts with the heading contents. Correct? Now, it says terms and conditions. But what starts at page 1 is some commercial terms and conditions. Correct?
Yes, madam.
Now, after conditions, the next heading is specification. Then where are specification? After specification, questionnaires. Where are the questionnaires? Where is the data sheets? Where is the performance curve? Where is the spare parts? If you can show me all this, then you have a case right now and I'm going to give you the judgment right now.
If
But,
my lords
but you
will-
have to show it.
I'll show that, my lord. If my lords, because this same document was exhibited by the state respondents at the time of trial.
Yes.
Now that is in page 751, my lord.
700.
51.
Yes.
Now this is the contents, if my lords will see the contents there.
Yes.
One is agreement in non-judicial stamp paper. So the next page is the contract agreement.
Yes.
And then letter of intent is also there.
Yes.
And then the description and scope of work
Yes.
is also there. And then comes the amendments. Amendments is at page 759. This is the same commercial terms and conditions which I've just
Seven.
shown. 759.
This is part of what document? Annexure?
This is part of the annexures of the state respondents. They've annexed the same contract agreement in their written statement.
Okay.
And it was also exhibited by the appellant as Exhibit P2
All
for
right.
the Lane Trial Court.
Exhibit?
P2.
Yes. Yes.
If my lords will see page 896. I'm so sorry, my lords, I'm going here and there, but it's required.
800?
96. I will give my submission in writing also, my lords.
800?
96. 896.
Yes.
So if my lords will see Exhibit P2. Exhibit P2 is a contract agreement containing 255 pages.
This is by whom?
This is by the appellant. So the contract agreement contains all these commercial terms and conditions. It's all inclusive of the contract agreement.
Yes.
Shall I go to the impugned judgment, my lord? My lords, 6 issues were framed. One is page 955.
He started from page 12 and he goes in 100. No? 900?
55.
55.
There, my lords, 6 issues were framed, and I mainly agreed with.
Have you seen page 2? The name.
My lord.
Yes.
6 issues were framed, and I mainly agreed with the decision of the Lane Trial Court in issue number 4. The issues are whether the suit is maintainable or not. Number 2, whether the plaintiff has completed the allotted contract work successfully as per the terms and conditions laid down in the contract agreement, and whether the plaintiff violated any.
You are only concerned with issue 4.
Issue 4, mainly with issue 4.
Okay.
Others, the admitted liability have been paid.
Okay.
That I'm not disputing.
Okay. So
Shall I?
when was the admitted dues paid? Pending the trial?
No, my lord. Previously, I've approached this honorable court, and that was in 2005. Then, after that, judgment order was passed, and then I was paid. And this suit was filed in 2007.
After?
After, yes.
Yes.
Shall I read the
Yes, yes, yes.
page from page 4, my lords? I'll read
Page?
page 4. 956. 956.
Huh?
956. Yes.
I thought you were going back to
Inner
page.
page. My lords.
Yes, you can read slowly, huh?
Yes, yes, my lord. PW1 in his examination in chief, being the plaintiff, reiterated his averments and submission in the plaint. He further deposed that he had exhibited 14 documents, my lords.
Yes, yes, read. Not, you don't have to read the document.
Yes, yes.
In his
In his cross-examination, he deposed and admitted that as per their agreement dated 25/11/1993, the duration of the work is to be completed within 36 months. He admitted that the set period of work is mainly for Greater Searcy Water Supply Scheme. He also admitted that Tuikum Weir extension is not included within the original agreement. He denied that payment of interest at 2% per month is not included in their agreement. He denied, my lord. He admitted that as per clause 10 of the said agreement, there is a provision for training of the engineering personnel free of cost by the contractor, but he denied that the contract violates the said clause. He did not remember that whether there was an order from the defendant to purchase a valve in order to run the said water supply scheme. He denied that there is no provision for buying a valve within the agreement. He admitted as a fact that he did not submit any voucher or receipt of the said valve when he claimed and submitted his bill to the defendant. He stated that he have already submitted completion drawing as per clause 14 of the agreement to the concerned executive engineer of the said work, but he have no any receipt showing that the said completion drawing are actually received by the EE. He admitted that he had received his bill from the defendants in various installments, but he did not know the exact bill amount which he had received from the defendants. He admitted that a copy of his completion drawing was not enclosed in the instant case. He did not know what is the amount of interest which he have been claimed out of the total amount of his claims. He cannot say the exact amount of the estimate of Tuikum River. He did not know the estimated amount of Greater Searcy Water Supply Scheme. He admitted that he did not receive any written order from the defendants to supply non-return valve and score valve. He stated that he claimed interest as per Annexure 1 and 2 of the claim. These are the contract agreements, Annexure 1 and 2. In his re-examination, he further deposed that being a contractor, he never insisted a receipt for submission of completion drawing akin to the instant case. The construction of extension of Weir at Tuikum River was done by him as per the written order from the concerned authority as Exhibit P3. The PW2 in his examination in chief deposed that as he was employed as project manager by the plaintiff, he knew the facts of the case. The plaintiff had executed contractual works of intake works, raw and clear water pumping station, including booster pumping station, so and so, with associated equipments, testing, commissioning, and operation and maintenance of all works for 12 months for Greater Searcy Water Supply Scheme. By doing so, the said contractual works, the plaintiff and the government of Mizoram, represented by the Chief Engineer, PHE Department, signed an agreement on 25/11/1993. The plaintiff thereby agreed to complete the said work for a sum of rupees so and so on the terms and agreements contained in the said agreement, and the government of Mizoram also agreed to pay the contract price as provided in the said contract agreement. The contract is for 3 years from the date of signing, with the provision for extension in view of unforeseen reasons. He knew that the plaintiff had completed the said work on 30/11/1997 and thereby commissioned on 19/12/1997. The defendant number 2 further extended the scope of the said work by directing the plaintiff to start construction of extension of Weir at Tuikum River at the estimate cost of rupees 55 lakhs as per the letter dated 23/1/1998 issued by the defendant number 4. The plaintiff also completed construction of Weir at Tuikum River on 30/12/1998 to the satisfaction of the government of Mizoram. The plaintiff thereby submitted his bills to the concerned authorities. Due to failure of payment of bill amount, the plaintiff also served legal notice on 4/3/2004. There was a huge difference between the outstanding liability amount submitted by the defendant number 2 to the defendant number 1. In the terms and conditions in the agreement, there was a provision clause for payment of interest at 2% per month in favor of the plaintiff. In his cross-examination, he deposed that being a project manager under JEP, he had been looked after the construction till today. The payment made by the defendants to JEP was sometimes received by him and sometimes by others. He cannot say the exact amount already received by him in connection with the instant case. He denied that the contractual agreements did not provide interest at 2% per month for delay payment of bills. Since he did not keep the account, he cannot say how much amount has been accepted by the contractor against the defendant. After completion of the work, necessary drawing was submitted to the defendant as per agreement as prepared by the consultant, namely so and so, but the said copy is not enclosed in the instant claim. And the defendants have examined 4 witnesses. I'll start with DW1, my lord. The DW1 in his examination in chief deposed that no interest laws have been incorporated in the contractual agreement. The instant construction of extension of wear is a separate work and not included in the said contract agreement. Supply of additional valve is beyond the scope of the contract and formal order for supply of the same was not issued by the department. The plaintiff fails to submit completion drawing. Full payment to the tune of rupees 55 lakhs was already made to the plaintiff for the extension of wear at River Tuikum for 5 times supported by voucher. The amount of the contract awarded to the plaintiff for Greater Serchhip Water Supply Scheme is rupees so and so and already paid rupees so and so. The total amount lying pending for the same is rupees 6,32,350 only. The abstract of details of payment made to the plaintiff is also annexed as Annexure 6 to 26. The plaintiff is therefore not entitled to the relief which he claimed in the plaint. In his cross-examination, he admitted that the instant project was commissioned in 1997. He also admitted that there are more than 1 valves in the pump house and in the pumping main.
What does that mean?
Means they directed him to repair the valves. Commissioning of the project did not denote that the project was completed successfully by the plaintiff. Clauses 11 and 12 of the amendment of agreement relates to supply and installation of valves in the pumping main. He denied that the plaintiff already submitted the completion drawing. In his re-examination, he further deposed that the admitted liability due to the plaintiff by the department is payable only upon submission of completion drawing. The DW2 in his examination in chief deposed that no interest laws have been incorporated in the contractual agreement. The plaintiff did not complete certain item of works on 30/11/1997. The instant construction of extension of wear is a separate work and not included in the said contract agreement. Excessive and unreasonable claims of the plaintiff has no connections with the terms and conditions of the contract agreement. As per the contract agreement, the stipulated period for completion of the work was for 36 months, but the plaintiff could complete the work partly only after 28/8/1998. The amount due to the plaintiff by the defendants mentioned in the written statement should be read as rupees 7,50,100, but only which is not the fault of the defendants as it is due to non-submission of satisfactory completion drawing of the work. As soon as submission of satisfactory completion drawing, the said rupees so and so will be released to the plaintiff. In his cross-examination, he deposed that there was an agreement with the plaintiff and the defendants in 1993 for intake, works, raw and clear water pumping station, including so and so, along with associated equipments, testing, commissioning, and operation and maintenance for Greater Serchhip Water Supply Scheme. As embodied in the agreement, he admitted that the plaintiff had started the work. He also admitted that the project was commissioned successfully on 19/12/1997. He admitted that his statements based on verbal discussion and instruction of his colleague. He did not know how much amount is paid to the plaintiff by his department. He did not know how Exhibit P7 was originated. The DW3 in his examination in chief deposed that he had been posted.
He doesn't know from where Exhibit P7 has originated.
Yes.
That P7 is that document.
No, my lord.
Okay, go on.
It's more or less the same. The positions of the state evidence, the state respondents, they are all denying that the interest clause is incorporated in the contract agreement. Now I will go to the findings, my lord.
Yes.
Number 1, whether the suit is maintainable or not. Page 961.
Yes, read.
The plain duly accompanied by verification by affidavit in the paragraph wise by making payment of requisite court fees is unchallenged in the later proceedings of its maintainability. Thus, this issue is decided in favor of the plaintiff. Then issue number 2 is also issue number 2. Whether the plaintiff has completed the allotted contract work successfully as per the terms and conditions laid down in the contract agreement, and whether the plaintiff violated any other terms and conditions in the contract agreement. In the contract agreement signed on 25th November 1993 by parties marked as Exhibit P2, it was clearly covenanted that now therefore in consideration of the mutual covenants and agreements of the parties herein contained and to be performed, contractor hereby agrees to complete the works for the sum of rupees 5 crore 46 lakhs and 50,000 only and on the terms and conditions herein contained, and government hereby employs the contractor and agrees to pay him the contract prices provided herein for the fulfillment of the works covenants set forth herein. The further terms and conditions and covenants of the contracts are set forth in the enclosed sheet, each of which are attached hereto. In consideration of the payments to be made by the government to the contractor as herein after mentioned, the contractor hereby covenants with government to execute the works in conformity with the provisions of the contract. The government hereby covenants to pay the contractor in consideration of the diligent and proper execution of works the contract price at the terms and conditions and in the manner prescribed by the contract. As per the Annexure 3 in the written statement of the defendants, vide letter so and so.
I think issue 4 would be relevant.
Yes, yes. I'll go to issue 4, madam. That is at page 965.
Yes.
Shall I read, madam?
Yes, please.
Issue 4. Whether any terms and conditions for payment of interest on delay payment in the agreements of contract in between the parties. At the time of arguments, learned counsel for the plaintiff relied in one Xerox document, namely commercial terms and conditions. It runs that should you be not able to make payment for reasons beyond your control in time, we shall have the right and liberty to charge you due compensation, and you will have to pay us such compensation within a period of 1 month from the date of such claim. Compensation is to be made at the rate of 2% per month of the amount of money blocked by you. The language itself reveals that it was a letter sent to the defendants by the plaintiff, but whether the same is incorporated in the contractual agreement or whether the defendants accepted the same is not found on perusal of case records, including the minutes of the huge contractual agreement. So is the factum it is relevant to follow the principles emerging.
So that issue 4 is very limited.
Yes.
But that's all you need to show? Because you're only concerned with issue 4.
Yes, mainly.
What do you mean by mainly?
Because I have filed the suit only for payment of interest.
That's right.
Yes, yes.
So that they are relying on a decision of the apex court.
Yes.
And they're saying unless it is there in the terms and condition of the contract, one cannot claim interest as a matter of right.
Yes.
Correct?
Yes.
Now you are relying on a particular, it appears it's like a letter because it is sent by you. Because you are saying we, and then you are saying you are liable to give me interest. But the fact that they have accepted this,
yes, there
is no clear any document showing it. You insist it's part of that commercial contract, but they don't they accept that in the written statement. Where is the averment in the written statement by where they have enclosed that annexure 2? Because in their deposition, have you asked this question, if this is part of that contract agreement, and what did they say? Because Mr. Tliana, you have to show before this court that this is proof that it is part and parcel of the contract agreement.
I understand.
Because you see, in the initially only I pointed out this question to you because it does not seems to be a agreement. It's something like you are telling them.
But
no, you hear it out. I don't get intimidated. I'm not against you. I'm trying to understand the facts because I have to author a judgment, right?
Yes, yes.
Now, you have to project a clear-cut contractual clause whereby they are bound to give you the interest. What you are relying is something like one-sided, which again is also disputed by the other side, that is part of that contract agreement. So the onus is very heavy on you. It is only your witness, plaintiff witness 1, who says that it is part of that.
Yes.
But what about their evidence? Where have you brought this in the cross-examination? And how do they respond? Okay.
If, Your Lordship, if I may, I have just received this WhatsApp message from the department stating that there is an arbitration case number 8603 of 2023. It's with regards to this case, Johnson Eastern Power, and the next date of hearing is at the principal seat on 22nd of May. So, they are stating that this case had already been transferred to the principal seat.
Which case?
This RFA.
This RFA?
Yes, my lord.
RFA has been transferred? How?
There is a, it appears that there is a case.
No, that's okay.
They have filed another case at the principal
arbitration
seat.
case?
Yes, my lord. With
Is there a
regards to-
judicial order whereby they have tagged the RFA 10 to
They
be
have
listed
not-
before the arbitration bench?
They have not yet sent me that, but however, the next date of hearing is on 22nd of May.
What to do, Mr. Tlana?
I'm not aware of that, my lord.
I was also not aware of that, but I have just received from the department.
I think it's better that you get more clarity.
Yes.
Yes, my lord.
When can I have it? After 22nd May?
After 22nd May.
In the meantime, you get hold of the judicial order if there is anything.
Yes, my lord. I will do
You
that.
find it out. Heard Mr. Oh, sorry. You write it. Heard Mr. Tlana, Learned Counsel appearing for the appellant. Also heard MS Caroline, Learned Counsel appearing for the respondent. MS Caroline, Learned Counsel for the respondent submits, right? Submits that she has received instructions from the department informing her that an arbitration matter involving the issue before this RFA is pending before the principal bench at Guwahati. She seeks a short accommodation for placing further instruction in the matter. Repost on such and such date.
2nd of June. Hearing list, item number 2.
Call the PS. Sorry, I gave it to you. This is item number?
Item number 2, my lord.
24.
Item number 2, hearing list, my lord. Part 2.
Oh, hearing list.
May I start, my lord?
Yes.
My lord, this is a regular first appeal challenging the judgment and order dated 12 June 2024, passed in civil suit number 47 of 2021. Basically, my lord, here in the this judgment, we were directed to pay 10,30,000 to the respondent herein, my lord.
Mr. Phila.
I'm Lalwat Puya Silo, my lord.
Remrat Phila.
Yes, my lord.
Oh, you are Silo.
I'm Silo, Mr.
So, Mr. Silo, who is this David, the appellant, who is he?
He's my client, he's the defendant in the suit. civil
He's
suit.
the defendant.
Defendant
And
number one.
the respondent was the plaintiff.
Yes, my lord.
The suit was for
Suit was for recovery of 13 lakhs 30,000, my lord.
recovery of 13 lakhs
30,000.
30,000.
Yes, my lord.
Of what? 30,000.
10 lakhs 30,000 was alleged to be paid to me by the respondent, my lord. Wherein it seems like the allegation of the plaintiff, the respondent in the suit is that I offered the post of general manager, and since the respondent husband was not promoted to the post of general manager from superintendent of engineer PNE, so they want refund of that money, my lord. It's a bribe money actually, if the allegation is true.
How can it be given? It's a bribe money.
It seems, if the allegation is true, my lord, that's what I'm saying.
Then what did the trial court do?
Trial court is like passing a decree directing me to pay 10 lakhs 30,000 to
The bribe money.
Yes, my lord. And my lord, before the
If it's a
pronouncement,
bribe money, then let me put you both inside.
my lord, before the pronouncement of the judgment in the district court, my lord, actually I did not find this judgment, wherein I almost exactly the same case is there, my lord.
Dina. No, you stay there. Why are you coming? Yes.
My lord, in our case, it seems like the appellant herein is like promising the husband of the respondent to the post of general manager at technical branch under human resource department, wherein and in that promise, the allegation is that I demanded 10 lakhs, my lord. And in this case, which I rely, my lord, it's almost the same. This here it's my lord, it's in this case it's a suit filed under, it's a writ petition filed under.
Even without this judgment, I would have given you this. I have already indicated if it's a bribe money, the trial court couldn't have enforced it.
Yes, yes, my lord.
I've already indicated. Now you have to show it to me.
So which?
You have to show me from evidence that it's a bribe money.
Yes, my lord. My lord.
You want the
Yes,
case law to apply. It has to apply to the context of your case.
My lord, before I take you to the evidence, let me take you to page number 39 of the paper book, my lord, wherein issues were framed, my lord.
Page number?
39 of the paper book, my lord. Page number 39 of the paper book, my lord. May I read out, my lord?
Yes.
39 of the paper book, my lord.
Yes, yes.
The following issues were framed. It's the order dated 11/4/2023. My lord, number one is whether the suit is maintainable in its present form and style or not. Number two, whether the plaintiff has located standby to file the present case or not. And number three, it's very relevant, my lord. Whether the defendant number one, who is the appellant herein, deceived the plaintiff in the name of the defendant number two by offering the post of general manager at technical branch under human resource department to her husband. If so, as to whether the plaintiff has paid rupees 13,30,000 to the defendant number one, for the same. More or less, it's a criminal offense if the allegation is correct, my lord, according to my understanding, my lord. And here, my lord, even the payment of 10,30,000, which I am directed to be paid, my lord, no documentary evidence was there to show that I received 10,30,000 from the respondent, my lord. If I take, my lord, to the page number 43 again, my lord.
I have not understood anything. You have to, you take, where is the impugned judgment?
Impugned judgment is in page number 52, my lord. Sorry.
Page?
52, my lord.
You read that.
Okay. May start from 53, my lord. Relevant part is there. Page number 53, my lord.
Yes.
During the year of 2017 to 2020, the relatives of the defendant number one used to rent the building of the plaintiff, and the defendant number one also sometimes joined his relatives, and they built a good relationship with the defendant number one during those years. The defendant number one addressed himself as the Indian Railway Board member, having close connection with the central BJP leaders. In the year 2017, the defendant number one being addressed himself as a close friend of Sri Rajiv Kumar Jaswal, the then National Secretary, Rashtriya Lok Samta Party, Bihar, who is also the chairman of Indian Railway Board, offered and promised Mr. Thang Zagina, the then Superintendent of Engineer, P&E Department, Government of Mizoram, who is also the husband of the plaintiff, a post of General Manager at Technical Branch under the Human Resource Department. For the same, the defendant number one told the
So
plaintiff...
this is the plaintiff's plea.
Yes, my lord.
Where is the plaintiff lawyer gone? Huh? How can he just go? Yes. How come you can how come you've just walked out?
So I got frustrated, then I asked my friend to stand on behalf of me.
No, but there was no one.
My friend, can I stop?
There was no one here. This is not how. Please maintain some decorum in the court, Mr. Counsel. You're not supposed to walk out during the middle of a hearing. If there is something, you seek liberty, and then go. There could be an emergency, but you can always seek that permission. It does not look proper. You must maintain some decorum of the constitutional courts.
My apologies, my sincere apologies, sir.
At page 53, your case is, Mr. Counsel, I'm referring to you, Mr. Ramrot Fela.
My lord.
You see, your case is very clear. Your own case in your own pleading, that you have entered into an arrangement with the defendant on the promise of the defendant that he is going to give you a post in the railway,
My lord, actually,
for which you have to pay 10 lakhs. And if he can't give you that post, he'll return that 10 lakhs. Now, so happens that you deposited the 10 lakh in his account, but he did not give you the post. So you have filed a suit, and the trial court has also given you this money back.
Correct,
But
yes.
this is totally illegal.
Actually, my lord, I'm being cheated by the appellant.
Huh?
I'm being cheated.
No.
Because it was not the right money.
You may be cheated. You go before the cheating court. You go before the criminal court. You want to enforce an agreement, then that agreement has to be legal. This is absolutely illegal. This is bribe.
Actually,
you want this court to now put a seal to corruption?
It is not the bribe money because from the evidence it is clear.
Mr. Counsel, your own case.
From the evidence it is clear. It is
Forget
not a bribe.
evidence. Where is your plaint? Where is your plaint? See what is your own pleaded case.
Plaintiff is from page number 1, my lord.
Page number?
Page number 1.
1.
One of the paper book. And the relevant part is in paragraph number 3, my lord.
Paragraph number?
3.
Yes, Mr. Ramrut Fela. Read paragraph 3.
Page number 2, paragraph number.
Read.
That in the year 2017, the defendant number 1 being addressed himself as a close friend of Sri Rajiv Kumar Jaswal, the then National Secretary, Rashtriya Lok Samta Party, Bihar, who is also a chairman of Indian Railway Board, offered and promised Mr. Thang Zagina, the then Superintendent of Engineer, P&E Department, Governor of Mizoram, who is also the husband of the plaintiff, a post of General Manager at Technical Branch under Human Resource Department. And for the same, the defendant number 1 told the plaintiff that in pursuance of information received from Sri Rajiv Kumar Jaswal, an amount of rupees 10 lakhs needs to be deposited on his bank account with the condition that In case the defendant number 1 fails to put Mr. Thang Zagina, the then Superintendent of Engineer, PNE Department, Government of Mizoram, who is also the husband of the plaintiff, to the post of General Manager at Technical Branch under Human Resource Development Department, the deposited amount would be fully returned accordingly. And the same has also been impliedly admitted by the defendant number 1 in his reply of legal notice sent by the plaintiff.
Now you tell me, which law of the country
My Lord,
allows such a thing? Tell
my
me.
Lord, actually, as per my humble understanding, the appellant approached me and offered a job for my husband.
Mr. Counsel, I'm not on all that.
Yes, because
my sympathies may be for you, but if you want to enforce this obligation, it has to be legal. Can he legally provide you the post in lieu of rupees 10 lakh from you? Is that legal?
as per my understanding, it is a mandatory requirement.
No.
Because he told me that an amount of 10 lakhs need to be deposited.
No.
In order, because we only fulfilled as directed by the appellant. There is no cheat and bribe because, my Lord,
Yes.
please, you also make a return page number, page number 59 of paper book.
Page
number 59 of paper book.
Yes.
It is issue number 3.
Yes.
May I read?
Yes.
Whether the defendant number 1 received the plaintiff in the name of the defendant number 2 by offering the post of General Manager at Technical Branch under Human Resource Department to her husband, and if so, as to whether the plaintiff has paid rupees 30,30,000 to the defendant number 1 for the same. And the plaintiff has stated in her examination in chief on affidavit that in the year 2017, the defendant number 1 addressed himself as a close friend of Rajiv Kumar Jaswal, the then National Secretary RL Rashtriya Lok Samta Party Bihar, who is also the chairman of Indian Railway Board, and yet he offered and promised me, her husband Thang Zagina, the then Superintendent of Engineer, PNE Department, Government of Mizoram, a post of General Manager at Technical Branch under Human Resource Development, and that an amount of rupees 10 lakhs needs to be deposited in his bank account because he directed me to deposit 10 lakhs. He thinks that it's a mandatory required.
Where did you
with the
say?
condition that it is page number 59.
Where you said it's a monetary condition.
In case the defendant number 1 fails to comply with the offer, the deposit amount would be fully returned.
It says that he has offered the post of general manager, for which he demanded this money, which you paid. This is what it is. For offering the post of general, it doesn't say that this is required as some condition, that this money is, sorry.
My Lord, according to the Black Law Dictionary, bribe was defined as the act of offering, giving, receiving, or soliciting act or something of value to influence a public official or legal duty holder. But in the instant case, there was no receiving and offering of money. I simply deposit amount of money as directed by the appellant in a good intention.
Your intention may be good, but for what?
In order to fulfill the mandatory requirement as alleged by the appellant.
Sorry, I am not convinced.
My Lord, I totally object the supposition of my learned friend. In fact, the case of Engkung and the instant case was completely different. Because the instant case speak about...
Why did you not file any criminal case against him?
Because, my Lord, it is a money matters.
No. What money matter? You are saying cheating? You are saying deceiving?
It has to be under 415 IPC.
Why have you not filed? Because you know it very well that if you file that, you might also get into trouble.
Not at all, my Lord. If I file criminal case, I may not have a chance to recover my money. That's why.
No. You should have filed a criminal case as
Actually,
well.
My Lord, if I may add one more point, my Lord. Apart from that submission, my Lord, there is no documentary evidence to prove that I received 10 lakhs 30,000 from the plaintiff, from the respondent, my lord. Even from the evidence, it's clear, my lord. It's from the own admission of the plaintiff, my lord. It's in page number 43 of the cross-examination, my lord.
Page number?
43, my lord. 43.
Yes.
Point number 5, my lord.
Yes.
That I do not remember the exact dates when I handed over money to the defendant number 1. It is a fact that there is no documentary proof to prove that I handed over 13 lakhs 30,000 on various dates. And point number 7, my lord. It is a fact that I do not have any documentary proof to prove that the defendant number 1 is liable to pay me rupees 13 lakhs 30,000. And
Yes.
again, in page number 48, my lord, the husband of the plaintiff. Point number 4, my lord, page number 48.
Michael, more, how many matters are there in the division bench?
There are 2 matters for civil benches, around 5.
This could also.
May I take my lord to page number 48, my lord, again?
Yes.
Point number 4 is relevant, my lord. It is a fact that I cannot produce documentary proof to show that we handed over an amount of rupees 10 lakh 30,000 to the defendant number 1. In fact, there was no document at all, but still the trial judge directed us to pay the money to the respondent herein, my lord.
Just complete reading from page 53. Give a quick reading.
From paragraph number 2, my lord.
Para 1.
Paragraph 1. During the year of 2017 to 2020, the relatives of the defendant number 1 used to rent the building of the plaintiff, and the defendant number 1 also sometimes joined his relatives, and they built a good relationship with the defendant number 1 during those years. The defendant number 1 addressed himself as the Indian Railway Board member, having close connection with the central BJP leaders. In the year 2017, the defendant number 1 being addressed himself as a close friend of Sri Rajiv Kumar Jaiswal, the then National Secretary, Rashtriya Lok Samta Party, Bihar, who is also the chairman of Indian Railway Board, offered and promised Mr. Thang Zagina, the then Superintendent of Engineer, P&E Department, Government of Mizoram, who is also the husband of the plaintiff, a post of General Manager at Technical Branch under Human Resource Department. For the same, the defendant number 1 told the plaintiff that in pursuance of an information received from Sri Rajiv Kumar Jaiswal, an amount of rupees 10 lakhs needs to be deposited on his bank account with the condition that in case the defendant fails to put Mr. Thang Zagina, the then Superintendent of Engineer, P&E Department, Government of Mizoram, who is also the husband of the plaintiff, to the post of General Manager at Technical Branch under Human Resource Department, the deposited amount would be fully returned accordingly. May I continue the second paragraph? As the plaintiff do not have such a high excessive amount on that moment, our husband Thang Zagina withdrew his GPF, and through which the plaintiff paid rupees 8 lakhs in cash in the month of April 2017 to the defendant number 1. And later the plaintiff paid the other rupees 30,000 to the same. Besides that, the defendant number 1 also addressed himself as a supplier of sandalwood, who used to supply the same in various parts of India, having a high income return. For the said purpose, the defendant number 1 further requested the plaintiff to lend 5 lakhs on the condition that the borrowed amount along with the interest would be paid to the plaintiff within a couple of weeks. The plaintiff, being honest and innocent without having any suspicion, after consulting her husband, handed over 2 lakhs to the defendant number 1 in check on 6/10/2018, and the other 3 lakhs was deposited in the bank account of the defendant number 2.
All right. Do you want to add anything? I'm going to
My lord,
step aside.
my sincere request is allowed me to make one more submission. The brief fact of the case is that the appellant approached me and offered a job for my husband, who is currently holding the post of Superintendent of Engineer in P&E Department, and telling me that an amount of rupees 10 lakhs need to deposit in order to hold the post of.
You're repeating.
Yeah.
You're repeating the submission.
But I will clarify afterwards, my lord. for holding the post of General Manager at Technical Branch Human Resource Development Department, which is equivalent to the rank of CE. CE is Chief Engineer, which is the immediate higher rank of Superintendent of Engineer SE. The post of General Manager Technical Branch is the actual post of the promotion post of SE. It is equivalent rank. And after I consult my husband, I deposit an amount of rupees 8,30,000 in order to fulfill the condition as directed by the appellant. So, my lord, in this case, there is no illegal and criminal offense in regards to the instant case as compared to the case law cited by my learned friend. Because according to the Black Law Dictionary, the term bribery was defined as the act of offering, giving, receiving, or soliciting something of value to influence a public official of legal duty holder, which means that there should be receiving or offering any undue reward to any person whose ordinary profession or business relates to the administration of public justice in order to influence his behavior and to incline him to act contrary to his duty. In the meantime, in this instant case, there was no such kind of offering on the part of me, and in spite of that, in good faith, I simply deposited an amount of money as a means of to fulfill the mandated requirement as directed by the appellant. Therefore, it is crystal clear that the nature of the case cited by my learned friend and the nature of the instant case is completely different.
All right, no.
So, my lord, in order to make the picture clear, your lordship may kindly turn page number 40 of paper book.
Yes.
This is my examination chief, and allow me to read also the cross-examination part also.
Yes.
From number 2.
Yes.
This is the repeated version. That during the year of 2017 to 20, the relative of the defendant number 1 used to run my building, and the defendant number 1 also sometimes joined as relative, and we built a good relationship with the defendant number 1 during those years because we trust him. And as the defendant number 1 addressed himself as Indian Railway Board member, having a close connection with the central BJP leaders, I laid full trust on the defendant number 1 and also treated him as our own family members. That in the year 2017, the defendant number 1, being addressed himself as a close friend of Sri Rajiv Kumar Jaiswal, the then National Secretary, Rashtriya Lok Samata Party, Bihar, who is also a chairman of Indian Railway Board, offered and promised my husband, as I said, that
Okay. This is reiteration of the plaint. I've seen it.
Yes.
Yes.
What I want to elaborate is that
He's a
the
habitual
evidence
cheater.
produced by me and my witness, although it's oral in nature, but we are the one who saw and had the transaction as mandated by Section 60 of Indian Evidence Act. So there was no irregularity and there was no cheat, there was no bribery at all. We simply paid the money in fulfillment of the mandated requirement as directed by the appellant.
All right.
So my humble submission is there was no cheat, there was no illegal offense. I submit
there was no
good faith.
cheating.
Yeah, there's no cheating.
There's
But
no
they
cheating.
cheated me.
There is
That's
no
why I'm the
cheating, but he
victim.
cheated you.
Yeah, I'm a victim.
I'm sorry, I'm not being able to appreciate your argument. There was no cheating, but he cheated you. Is that what you just said?
He cheated me. I am the victim.
No. You just said there was no cheating, but he cheated.
No. I am the victim, that's why. There was no illegal.
All right, enough.
In regard to the transaction of the money.
I've heard you.
My lord, in addition to the judgment which I just put, my lord, the Supreme Court judgment also is there, saying in.
Give it.
I supply along with the judgment, my lord, which is a relevant part is in 24, my lord.
The Goa State Cooperative.
Yes, my lord.
Paragraph?
24, my lord. It says that the
All
court
right.
cannot be used as a tool by a litigant to.
Okay, fine.
My lord, lastly, allow me to make additional submission. Because if there is a bribe, I will offer money. And
all right, Mr. Counsel, please take your seat. Heard Mr.
Lalroad Puya, my lord.
Yes, I know. Take your seat. Heard Mr. Lalruit Puya Silo, learned counsel appearing for the appellant. Also heard Mr. K. Remroth Fela, Learned Counsel, appearing for the respondent. By way of this regular first appeal, under section 96 of the CPC, read with 17(2)(b) of the Mizoram Civil Codes Act 2005, the appellant is assailing the judgment and decree dated 12/6/2024 passed by the Learned Civil Judge, Senior Division, Aizawl Judicial District at Aizawl, Mizoram, in civil suit number 47 of 2021. The brief facts of the case is that during the year 2017-2020, the relatives of the appellant stroke defendant number 1 used to rent the building of the respondent stroke plaintiff, and the appellant stroke defendant number 1 also sometimes joined his relatives, and they built a good relationship. Based on such relationship, it is the case of the respondent plaintiff that upon the appellant defendant number 1 addressing himself as the Indian Railway Board member having close connection with the central BJP leaders, in the year 2017, upon offering and promising Mr. Thangza Zina. He is the
husband of the respondent.
husband of the respondent plaintiff, the then Superintendent of Engineer, PNE Department, Government of Mizoram, a post of General Manager at Technical Branch under Human Resource Department, the respondent plaintiff deposited an amount of rupees 10 lakhs in his account upon being persuaded to believe that in order to upon the belief, upon being persuaded that upon depositing the same, the husband of the appellant respondent plaintiff shall be appointed thereof, with the condition that in the case the appellant defendant fails to put the husband of the appellant of the respondent plaintiff, the said amount shall be fully returned. It is the specific case of the respondent plaintiff that since despite depositing the aforesaid amount of 10 lakhs,
10 lakhs 30,000, my lord.
10 lakhs 30,000, the post having not been given to her husband in spite of such promise, the appellant defendant is liable to return the same. Accordingly, a suit being civil suit number 47 of 2021, a money suit,
Civil suit, my lord.
A civil suit for recovery of the aforesaid amount of rupees 13,30 lakhs from the appellant defendants along with interest and other reliefs was filed. Relevant paragraph of the aforesaid plaint reads as under quote unquote paragraph 2 to paragraph 10. No. 2 to paragraph 7. Okay. 8 good. The appellant plaintiff accordingly filed their written statement denying the payment as claimed to have been deposited in his account by the respondent plaintiff. Correct?
Yes, my lord.
The following issues were framed before the trial court, page 39, 1 to 4. In support of the issues framed, the plaintiff, the respondent plaintiff adduced how many evidence?
2 witnesses, my lord.
2 plaintiff witnesses, whereas the appellant defendant adduced
One. Appellant himself, my lord.
one witness adduced himself as a defense witness. Additionally, both sides also exhibited a number of documents as documentary evidence. Correct?
Yes.
Both sides, na?
Yes.
Apt? No. The trial court, upon hearing the learned counsel the trial court upon completion of the trial held as under quote unquote page 59
The order is on page 63, my lord.
page
63, my lord.
63
Yes.
quote unquote A to A. Mr. So-and-so learned counsel for the appellant submits that there is no documentary evidence whatsoever of the respondent plaintiff depositing the aforesaid amount of rupees 10,30,000 in his account, and hence the trial court order, judgment and decree is totally perverse and erroneous in law. He further submits that it is the admitted case of the respondent plaintiff as pleaded and proved that on the promise of the appellant defendant to give the post of what is the post
General
name?
Manager, my lord.
General Manager at Technical Branch under Human Resource Department to the husband of the respondent plaintiff an amount of rupees, the aforesaid amount was deposited in his account.
No, my lord, I deposited 80,000.
1 second. The aforesaid transaction was made, or say the transaction in question was made. He accordingly submits that even assuming the aforesaid transaction has taken place, it is apparent that the same has been done by the appellant plaintiff to secure the post of
My lord, not appellant plaintiff, my lord, respondent plaintiff.
respondent plaintiff to secure the post of general manager for her husband as promised by the appellant. The same being by way of illegal gratification cannot have been enforced by the trial court. In support of the aforesaid, he relies upon the decision of the apex court in the case of so-and-so versus so-and-so, reported in 2019, volume 20 SSC, page 38, and the decision of the coordinate bench of this court in the case of so-and-so versus so-and-so, reported in 2014, volume 4 GLR at page 354. Per contra, give me that definition you are relying. Per contra, Mr. So-and-so, learned counsel appearing for the...
My lord, I've already submitted.
Huh?
Affidavit in opposition. I've already submitted.
That dictionary meaning?
Yes.
Where do I get it?
I think in the file. I already submitted before the
Get
court.
it? No, that
Affidavit in opposition.
So submits that the respondent plaintiff, in order to fulfill the condition as promised by the appellant defendant for offering against the subject post to the husband, to her husband, has made the subject deposits, and hence the same cannot by any stretch of imagination be termed as illegal gratification and or bribery and or bribe. Where is that dictionary meaning?
Maybe my lord, page number 3 or 4.
He further relies upon the dictionary meaning of the word bribery as defined in the Black's Law Dictionary, which defines bribery as, within quote, the act of offering, giving, receiving, or soliciting something of value to influence a public official of legal duty holder. He further submits that the trial court has correctly assessed the evidence on record to conclude that the appellant defendant number 1 has deceived the respondent plaintiff by offering the subject post to her husband, for which she has paid rupees 13,30,000, and hence the order, judgment and decree of the trial court decreeing the suit in her favor by directing the appellant defendant number 1 to make a payment of rupees 10,30,000 to her ought not to be interfered with. I have given my due considerations to the arguments advanced by both the parties and have perused the materials available on record. I have duly considered the citations cited at the case law cited at the bar. It is opposite to refer to the issue which falls for determination in the instant appeal is whether the civil suit filed by the plaintiff for recovery of the amount paid to the defendant on the promise that the husband of the plaintiff would be appointed as general manager at technical branch under Human Resource Department is enforceable in law. It is apposite to refer to the evidence adduced by the parties. PW1,
Page 43, my lord.
page 40, na?
43, my lord.
PW1 is 40 or?
Cross-examination is in 43.
No.
The position is
The evidence in chief of PW1 reads as under, quote unquote, page 40 to 42. The cross-examination reads as under, quote unquote, page 43 to 44. The examination in chief of the husband of the petitioner, PW2, reads as under, quote unquote, page 45.
Husband of the respondent, my lord.
Husband of the respondent plaintiff, page 45 to 47. Cross-examination, page 48. The examination in chief of the defendant, of the appellant stroke defendant number 1, reads as under, quote unquote, page 49. Cross-examination, page 51. It is evident from the above that on the promise and on the promise of the appellant defendant number 1, that upon deposit of rupees 10 lakh in the account of the appellant petitioner, appellant defendant number 1, the husband of the petitioner would be appointed to the post in question. Husband of the respondent plaintiff would be appointed to the subject post. The respondent plaintiff deposited an amount of rupees
8,30,000.
8 lakhs 30,000. In Engunga Supra, the coordinate bench of this court has held as under, quote unquote, para 4 to 10. In Goa State Cooperative Bank Limited, the apex court has held as under, quote unquote, para 24. It is, though the learned counsel for the respondent plaintiff,
my lord,
were contended that the subject transaction was necessitated in order to fulfill the condition stated by the appellant for securing the post in question for her husband, and not in terms of any illegal gratification or bribe. This court is not inclined to accept such contention of the learned counsel appearing for the respondent plaintiff. It is manifestly demonstrated on the face of the record that it is due to the promise of the appellant plaintiff, respondent defendant, that upon payment of rupees 10 lakhs, the subject post shall be made available to the husband of the respondent plaintiff, failing which the money will be returned. There cannot be any other explanation. There cannot be any the aforesaid by no means can be said to be legal. It is absolutely clear that in order to get the post in question, the aforesaid transaction has been made by the respondent plaintiff. The aforesaid transaction has no legal sanctity. In other words, it is an illegal, it has been done in order to secure the subject post in question without there being any agreement, without there being any legal basis for doing so. That being so, this court finds this court finds that the the suit for recovery is bereft of any merit whatsoever. Accordingly, the trial court's judgment and order dated so and so is totally trial court judgment trial court's finding is trial court finding on to didim ruba. It is apposite at this stage to refer to the findings of the trial court, which reads as under quote unquote page 59 paragraph 13. To 62. The aforesaid findings is totally perverse and erroneous, accordingly set aside.
My lord, regarding
is the case records here?
rupees 20 lakhs, 20 lakhs is different amount of money. 20 lakhs is the money as a means of transporting sandalwood. This was, in the instant case, the suit value is 13 lakhs 30,000, but my learned friend only stressed on the procurement of job. But it seems that he did not challenge the payment of rupees 20 lakhs as a means of transporting sandalwood, which was already decreed by the trial court. 20 lakhs. My learned friend does not challenge.
No, that is not here.
Here?
What 20 lakhs?
20 lakhs in his petition.
No, not in his petition. The
My lord,
trial.
I was directed only to pay 10 lakhs 30,000.
Correct, correct.
But I've deposited only rupees 8 lakhs 30,000 and 20 lakhs is about the transporting of sandalwood.
What 20 lakhs?
My lord, please kindly grant the judgment and order. My God.
Yes.
The judgment and order, page number.
Okay, I'll look into this. Page 60, I've seen it. You mean to say you have
Page number 60, yes.
Yes, I've seen it. The 5 lakh is on the condition that he borrowed amount with interest to be returned. Okay, I'll have a look at it. I'll edit it.
My lord, the fourth paragraph, Sweden Henvet over.
I've seen it. I'll look into it.
Right, my lord.
오늘 이 칸이 좀